May it please, Your Lordship.
Yes.
Lordship, this is a land grabbing matter. In this case, Lordship, the tribunal held the petitioner as a land grabber. Against that order, Lordship, I have filed this CRP under 115 section, read with 151 of the Code of Civil Procedure, Lordship. In this case, what happened, Lordship? The original owner of the land is one Lutfur Rahman, Lordship. I have entered with an agreement with Lutfur Rahman for purchase of the land, Lordship. That agreement I have annexed along with this petition as Annexure 1, page 15. Original is at page 17. Rehanuddin Chaudhary and Lutfur Rahman Lashkar. So Rehanuddin Chaudhary is the petitioner and Lutfur Rahman Lashkar was the original owner of the suit land. After this agreement, Lordship, I was placed into possession of the suit land and accordingly I came to possession of the suit land. But this original owner sold the land to one Hilaluddin Lashkar, that is Annexure 2, page 19, Lordship. This is the NOC in the name of, no, Lordship, this is the NOC by Hilaluddin in favor of the petitioner. After purchasing the land, by Hilaluddin entered with an agreement with Rehanuddin, oral agreement to sell that plot of land again with Rehanuddin, Lordship. So we have obtained NOC, Lordship. Before that, this petitioner filed a title suit for specific performance of contract. When he came to know that Hilaluddin already, Lutfur Rahman already sold out the land to Hilaluddin, then he, Lordship, not pursued the earlier title suit and that was dismissed for default. Later on, he came with a Lordship, with Hilaluddin to execute the sale deed in favor of the petitioner. So there was an oral agreement. Accordingly, after that oral agreement, they obtained NOC for selling of the land. But Hilaluddin also did not sell the land to the petitioner, but he sold the land to Tajuddin, that is the present respondent. So we have filed a complaint case and that is Annexure 3, page 21. Against both Hilaluddin and Tajuddin Lashkar. On 23/7/2014, complainant is present with one witness. The witness has been examined as CW1 and his statement is recorded. Peruse the complaint petition, statement of the complainant and the CW. Heard learned counsel appearing for the complainant. I found sufficient ground for proceeding against accused Hilaluddin Lashkar and Tajuddin Lashkar under section 417 of IPC. Accordingly, cognizance is taken under section 417 of IPC against both the above named accused person. Issue summon to the accused. So there was a complaint case filed by the petitioner against both of them. But Lordship, this Tajuddin filed this present land grabbing case, that is Annexure 4, page 22, against the petitioner. His case is that in the year 2007, he purchased the land from Lutfur Rahman, and though he entered with an agreement with the petitioner to sell the land, but later on the petitioner did not purchase the land. So he sold out the land to Tajuddin and handed over possession of the land to Tajuddin. And subsequently, the petitioner in the year 2015 grabbed the land, Lordship. So this is his case against the petitioner. We have filed our written statement. That is Annexure 5, page 29.
So the burden that you have not grabbed any land is upon you.
Yes, Lordship.
So how you have discharged that burden?
Lordship, that agreement could not be exhibited as because, Lordship, the agreement was exhibited as Exhibit 1 in Title Suit 55 of 2008, which was filed by the petitioner against the original owner.
Then if you fail to exhibit that document, how this finding is wrong?
Lordship, there are several judgments which says if my possession is not illegal, there was an agreement, and out of that agreement I was put to possession by the original owner. If my possession is not illegal, then there is no land grabbing. Rather, they ought to have filed a civil suit for.
No, without any title or right title and interest, can you get a possession of the land?
Lordship, on that ground, Lordship, he may be declared as an illegal possessor, but he cannot be declared as a land grabber. That is the requirement of the act, and also there are judgment of this court, Lordship, on this ground. The entire judgment was set aside. One is, Lordship, Anna rule. Judgment shakti bad. আমি উপরে রাখছি। This is one Anarul Haq alias Anar Hussain, and another one
No,
is
you come to the definition of land grabber.
Lordship. Section 2D.
Yes.
Land grabber means a person or a group of persons who occupy or attempt to occupy with or without the use of force, threat, intimidation, and deceit land over which he or they have no ownership, title, or physical possession, or includes any person who gives financial aid to any person or group of persons for taking up illegal possession. So my possession is not illegal, Lordship. I was put in-
Despite having no right title and interest over the
Lordship,
same.
that was subsequent, but when I was put into possession, that was not illegal. On the basis of this deed of agreement, I was put into possession. So this decision clearly stated that Anarul decision, Lordship. দুইটা citation। আনারুল আর আকন্দ, এটা আনারুল, এটা আকন্দ। ও দিলাম CRP 74 2018 extra copy daftar tarate paragraph 18, Lordship. As per section 2D of the Assam Land Grabbing Prohibition Act 2010, land grabber is defined as a person who occupies the land by illegal means as indicated in clause D and clause E of section 2 of the act, over which they have no ownership, title, or physical possession, and includes any person who helps financially or otherwise in grabbing the land. Thus, from the expression appearing in the definition of land grabber, a person or persons can be said to have grabbed a land over which they have no ownership, title, or physical possession. Therefore, one must bear in mind the connotation of the expression title, ownership, and physical possession. A land grabber must be one who must not have title or ownership or physical possession over the land. The distinctive or in between ownership, title, and physical possession clearly demonstrate that if a person has title or ownership or physical possession over the land, he cannot be a grabber of the said land. A person may not have title or ownership, but if he has been in settled physical possession of a land for a long time and the possession is not obtained by any illegal means, these lines, Lordship, he cannot be dubbed as land grabber, because in order to constitute land grabbing as defined in section 2E of the Land Grabbing Act, as transparent from the expression without any lawful entitlement and with a view to illegally taking possession, etc., there must be criminal intention Divorce criminal intention, mere unauthorized possession may not come with the definition of land grabbing, although there may be a civil dispute over title or possession. So my case is entirely within this paragraph, Lordship. I entered with an agreement with the original owner. He cheated me, Lordship. He sold the land to some third person without giving the land to me after taking a consideration amount, Lordship. Basing on this judgment, Lordship, the Abdul Mannan Akan, that judgment which was I have submitted 2022-0 Supreme Gauhati 603. Paragraph 19. When a person has come into the possession of a land, initially in any land, legal or authorized manner, and remained in physical possession of the land for a long time, without any interruption, one cannot come in one fine morning and file a petition under the Land Grabbing Act, even if such possession subsequently becomes unauthorized. A person may enter into possession legally under some authority or unauthorizedly. Once a person enters into possession of a land by any legal means or under any kind of authority, even if later on his possession is found to be not in conformity with the law, such physical possession of the person.
All right. But the question is at the relevant point of time.
There was an
Before
agreement.
the trial court, there was no such agreement.
Agreement was there, Lordship, only he could not exhibit the land. For that, your Lordship may remand it for retrial, Lordship. There is an agreement I have enclosed with my petition. And that on the agreement, your Lordship will
Where
find
is where is that petition?
agreement, Lordship.
Yes.
Annexure 1, page
No.
50.
Where is that petition? You enclose the agreement.
Which petition, Lordship?
You have submitted that. You have filed the petition with the agreement.
No, I have filed the agreement here with the petition. With
Where
this
is that petition?
is with this civil revision petition as Annexure 1, page 17.
No. Where is the document to show that agreement was placed before the trial court?
No, Lordship, that was not placed before the trial court. I have stated that I have enclosed that document along with this petition as Annexure 1. And your Lordship will find in page 17.
Whether that agreement is a registered agreement?
No, Lordship.
No.
No.
What is the value of the land?
Lordship, there are several judgments which says even on oral
I'm asking
agreement
you what
also
is the value of the land?
No, Lordship, on the basis of oral agreement also specific
No,
performance.
that's all right. There is no dispute about.
Yes.
I am asking you what is the value of the land?
Here it is, Lordship. 20,000 he paid on that day. Total consideration of rupees 50,000. And in that respect, after deducting of an amount of rupees 10,000 as a recovery of debt, which I had borrowed from you on last 4/11/2005 by executing a hand note and also having received.
Where is that agreement?
Page 15.
15.
15. This is the translated copy and original is page 17 and 18.
You have filed a written statement before the trial.
Yes.
Where is that written statement?
Annexure 5, page 33. And type copy, page 29. This is a handwritten written statement.
Typewritten is at page number
33.
33.
Yes.
33 is the handwritten copy.
Written statement of the OP.
Typewritten copy is Annexure 5.
Yes, Lord.
Where you have taken that stand that under one agreement you are in possession of the said plot of land?
I have stated in paragraph 6 that the statement made in para number 2 of the petition are partially admitted by the OP, but witness number 1 never physically possessed over the scheduled land, nor the witness number 1 maintaining possession and enjoyment by way of cultivating paddy. OP has no knowledge about deed number 1088 dated 15/3/2016. Witness number 1 never delivered first possession, physical possession in favor of the petitioner. The OP came to know about the registered deed so-and-so for which on author he filed a complaint by number so-and-so before the learned court of CGM Hailakandi, which is transferred to the court of additional. These are about the real facts, Lordship, paragraph 10, page 35. That the original owner and possessor of the scheduled land is one Lutfur Rahman Loskar, son of Lesanuddin Loskar of village so-and-so, who on 17/8/2006 executed a bainama in favor of the OP with a condition to execute a registered sale deed in the name of OP within 24/7/2008. In that bainama, rupees 50,000 was fixed as the value of the scheduled land.
Okay, okay. Now come to the impugned judgment, how the court has dealt with this issue. Issue number 3.
Yes. Whether the opposite party grabbed the suit land which is owned by the petitioner. In this regard, apart from adducing evidence by PWs 1 and 2 supporting the ownership over the suit land, the petitioner's side has exhibited the sale deed number so-and-so by which the petitioner Tajuddin Loskar purchased the suit land from Hilaluddin Loskar. In the recital of the said document Exhibit 1, it is clearly stated that the vendor had been in possession of the suit land which he had purchased on 16/11/2007 by the registered sale deed number 3501 of that year, and thereafter on the date of executing the sale deed, he has delivered and handed over the possession of the said plot of land to the present petitioner. Said fact vividly deposed by the PWs 1 and 2 in this evidence, and their evidence could not be rebutted by the opposite party except putting a suggestion, and a suggestion without admissible evidence cannot wash away the case of a party which is supported by admissible evidence. It is the settled principle of law that documentary evidence prevails over oral evidence. Thus, in the absence of anything contrary, it is clear that it is the PW2 Hilaluddin Laskar who was in physical possession of the suit land till he sold out the same to the petitioner Tajuddin Laskar, and on and from 15/3/2014, it is the present petitioner who has been in possession of the suit land. The opposite party as DW1 reiterated the same facts as narrated by him in his written statement pertaining to the fact that he has been in possession of the suit land from its original owner Lutfur Rahman, with whom he had executed an agreement for sale in the year 2006. But the opposite party did not produce that agreement for sale before this court for perusal so as to find out its admissibility in law. The opposite party also contended that thereafter he had filed title suit 55/2008 before the learned Munsif number 1 Hailakandi for specific performance of contract. But from his evidence, it is clear that the suit was dismissed due to non-prosecution. Similarly, the opposite party contended that he made a negotiation with Hilaluddin Laskar to purchase the suit land by fixing the value worth rupees 1,50,000, and accordingly no objection certificate was obtained from the office of the Deputy Commissioner Hailakandi. Of course, that aspect is admitted by the PW2 Hilaluddin Laskar in his evidence. However, the PW2 has reasonably explained as to why he did not execute the sale deed in favor of the opposite party. The PW2 categorically stated that after getting the NOC while he was pursuing the opposite party to pay the consideration amount, the opposite party declined to pay the same. Thereafter, due to urgency, he had to sell the said plot of land to the petitioner. Therefore, it is clear that the opposite party has taken different stand in different time. However, the stand taken by him in different times could not also be retained by him through cause and evidence. In each and every sphere, the opposite party is found in fault had the opposite party produced the agreement for sale showing that from that day he was in possession of the suit land and he got any decree of any court towards execution of the sale deed by said Lutfur Rahman, the matter would have been otherwise, but in the case in hand, the opposite party has miserably failed to substantiate that he had any right. And Lordship, the original owner filed a complaint case against Lutfur Rahman. That judgment I have procured from online, Lordship. There, his case is that this bayanama was executed fraudulently, but criminal court, Lordship, acquitted me from that case. There, Lutfur Rahman admitted that bayanama was.
So,
his
Mr. Kadir,
allegation is.
it appears that there was a document. It was also mentioned in the written statement, though the document was not exhibited before the trial court. Let the matter go to the trial court. Let the other side exhibit that document.
That is law, whether
Pardon?
whether in law, whether that is.
No, the court will decide.
If failed in the trial court. And they
No, before the trial court, that document was not exhibited.
That is the duty of the my lord.
No, that's all right, but stand of the present petitioner is that there was an agreement. And pursuant to that agreement, he was put in a position of the suit land.
But my lord, on the part of the figure of the my lord, the petitioner hearing before the appropriate trial court, whether in the additional court, my lord, this can be allowed for additional jurisdiction if there is no jurisdictional error as per section 115, my lord,
Hmm.
of the CPC, 115. Whether under section 115, my lord, the petitioner can get a chance whether if there is no jurisdictional error, my lord. And otherwise, my lord, I may refer to the agreement, my lord.
Hmm.
Whether in the agreement, as my learned senior counsel is submitting, that as per the strength of this agreement, he is in possession.
Hmm.
Whether this agreement shows that possession was delivered. It is not made. Whether the agreement shows that the
Hmm.
possession is not delivered.
Hmm.
Kindly, my lord, refer to. If I refer to the second report, page number 15. There is nothing in the agreement that you was put in possession on the date of execution of the agreement. My lord. Page number
Hmm.
15, my lord.
Hmm.
Page number 15 on the last part, my lord, from the date. May I mention, my lord? On last 4/11/2005, Your Lordship got it. By executing a hand note and also having received another amount of so and so today, I am promising and ensuring Your Lordship got it.
Hmm.
In writing that in any month or day within the next 24 to 2008, if the remaining, this is important, my lord, if the remaining amount is paid, I will be bound to transfer the scheduled land by executing registered sale deed in the office of the sub-register Hailakandi. If I do not do the same willingly, the same may get registered and my lord, regarding possession, and possession may be taken on the strength of this agreement. If I fail to execute my lord on receipt of the balance amount, then the possession can be taken, my lord. So where my friend showed that on the date of execution of this agreement, she has been put in possession legally, my lord, legally, my lord. The condition was that if I fail to, then my lord, she will be in possession, my lord. But when we found that she is not interested to, my lord, get the land transferred, my lord, and accordingly she had filed a performance case, my lord. In Brazilian performance case, she did not pursue, my lord. This is on default.
Hmm.
Then, my lord, the original land vendor sold the to my vendor Hilaluddin, my lord, in 2007, and after 7 years, possession by the Hilaluddin, he has validly transferred by registered sale deed exhibit 1, my lord. to me, my lord. And
Okay.
that is proved before the learned trial court that Gilaluddin was in possession, and
Okay.
I have been handed over the possession of the
Okay.
right of
Okay.
execution.
Yes, madam, while exercising the jurisdiction, revisional jurisdiction,
Lordship,
can this
though-
court remand the matter?
Lordship, yes, Lordship, as because this is in the nature of first appeal. There is an appeal provision as there was no appellate forum under Land Grabbing Act.
Mm.
115 is basically, Lordship, it's a first appeal. Though 115 we are exercising as because there the suit already decided by the land grabbing case already decided by the tribunal, Lordship. So 115 will come. But there it is in the nature
No,
of a first appeal.
maybe,
Lordship.
but you filed this revision petition
Yes, Lordship,
under
and
section 115.
yes, along with 151.
So
Lordship.
here,
151, your Lordship has ample jurisdiction to decide under 151 also, Lordship.
can you show any citation on this point that while exercising revisional jurisdiction, this court can remand the matter
Then
to
your,
the trial court?
then your Lordship may make it part third and I'll produce on some other day, Lordship.
Okay.
Otherwise, Lordship, that citation Abdul Mannan Akan, Lordship, already under 115, the judgment passed by the tribunal was set aside in that CRP, Lordship.
No, setting aside is a different matter and
Lordship.
remanding the matter is a different matter.
Remand, Lordship.
Art Miss R. Soduri, Learned Counsel, Senior Counsel, assisted by Miss Mr. Learned Counsel for the petitioner and Mr. Kadir, Learned Counsel for the respondent. Hard in part, release the matter sorted. 7th
Lordship.
of further consideration. This is at least the
Obliged.
matter is parted.
Obliged.
Can you do a next hearing day after 7, madam?
After 7.
Next hearing day after 7.
7th is hearing day, then 12.
14, Lordship, there are lots of matter already fixed. Second level already core second level already fixed, Lordship. 20 Wednesday, Lordship. Wednesday, then 21st.
Okay.
21st. Obliged, Lordship.
Number 5 for orders.
May I please, your Lordship?
Yes.
Lordship, this matter ought to have come for hearing, Lordship.
Service completed?
Yes, Lordship.
Whether the other side entered appearance?
Lordship,
No.
there is, the name is shown, Lordship. For respondent number 1 and 2.
Part means so and so, Learned Counsel for the appellant. None appears for the respondent on call. It appears that service in this matter has already been completed. LCA receipt. Mr. Goswami, you are here.
Yes, Lordship.
For hearing.
Okay. LCA receipt.
Yes, Lordship.
Service and also heard Mr. Goswami for the respondent. It appears that in this matter, service has already been completed and the record of the trial court has been received. And in that view of the matter, this is at least the matter for hearing.
Next,
After
next week.
next week,
week.
25 matter
Kano ho matter ito? 2000.
in usual course.
Lordship, 2005.
Item 6.
Wait, wait.
Hmm.
I have filed this petition on behalf of the petitioner.
Hmm.
For transfer petition, from the principal judge of family court to Tezpur court. On 4/2/26, this court was pleased to call for the records. The records have already arrived. I have taken steps. Another party has not appeared till now.
Another
Other party, for the.
not appeared.
Yes, respondent. TCR has been received, proceed.
When did you take step upon them? Upon the respondent?
No, he has not appeared.
No. When did you take step on him?
On 4/2/26 itself, on the passing of the order, I immediately took steps by speed post.
Can you track the consignment in the website?
I haven't gone through those. It may be presumed to have been received for it. But no, such a long time has been passed.
No,
Yes.
tomorrow again the other person will come and he will plead that someone has not been received by him.
And he has passed
Okay,
divorce petition.
Okay, we will direct the registry to track the consignment. Heard Mr. Ahmed, learned counsel for the petitioner. Office note dated 23rd/4/2026 indicates that neither ready card nor unserved notice returned till date with regard to the respondent. Recessal is the matter on 5th of May.
6th of May.
5th
5th.
of May, and also put up one up-to-date office note in respect of service of notice upon the sole respondent. And also track the consignment in the website of the department. List accordingly.
Number 25.
Hi, please, Lordship. This is an application.
You are for the respondent.
Number 1.
Okay.
2, 3 may be struck off, Lordship. So they are my sisters and brother and sister. Their presence is not required in this.
This IA is for
Condonation of delay. Condonation of delay of 243 days, although but literally delay is for 13 days. What happened, Lordship? In the first appeal, our application for condonation of delay was rejected. Thereafter, with the application for delay, we filed an RSA that was not registered. An objection was raised with the registry. We were compelled to withdraw this and we filed CRP again with an application for condonation of 197 days. That IA was allowed. Therefore, when the CRP was listed, that CRP is not maintainable. That's what we know. The order was passed, dismissing, giving us a liberty to file second appeal, and the period from filing of the RSA.
No. Total period is
Total period, Lordship, 243 days.
243 days. Out of which how many days you are entitled to as per
No,
Article
then
14?
Total over 940 days, Lordship. Then 940 days. Out
Okay.
of 940 days, 697 days for pursuing wrong forum.
6.
97 days. That
And
was
thereafter,
exempted.
it remains.
Then further 197 days lordship, it was allowed earlier in CRP, condonation delay, condonation of delay of 197 days, it was allowed in CRP, IA. So therefore 13 days remain.
No, that was allowed in respect of another proceeding which you did not pursue.
Oh, that was wrong for lordship.
No,
But
that's all right.
but that it was not allowed while giving liberty. That part was not.
Yes, sir.
allowed to do.
You have any objection in condonation?
File on the objection.
What is the ground?
In paragraph 14, we have category. I have created.
Is your affidavit available on this record?
In their objection lordship, they have just reiterated what we have stated, the facts. When the IA was rejected, when the CRP was filed, these things.
Not on the record.
Okay, date may be fixed lordship, let it be tagged.
In respect of 2 and 3, service completed. They refuse to accept it.
Yes.
Heard Mr. Professor, learned counsel for the petitioner. For the applicant and Mr. A. Borwa, learned counsel for the respondent number 1. Office note dated 6/11/2025 indicates that respondent number 2 and 3 refused to accept the notice. And in that view of the matter, notice deemed to have been served upon them. Mr. Borwa submits that he has already filed the objection in this matter, but the same has not been placed on record. Accordingly, it is provided that this is the matter. On Monday, next Monday, taking the objection filed by the respondent number 1.
Obliged.
26.
May it please, loss. My lord, my second appeal was dismissed for default, my lord. And in order at present 15, your loss may be pleased to pay this order, my lord. My lord, unfortunately, I was ill, my lord, and it escaped my notice. I have mentioned it in my paragraph 3, 4, and 5, my lord. I was badly ill and it escaped my notice. The matter was listed in the supplementary for list in the both page, my lord. So your lordship may please to peruse, my lord, paragraph 3 of my petition.
Madam, any objection?
Lordship, it is within limit, Lordship. It may be fixed for hearing.
Fixed for hearing. Okay.
They stood in fixed for you, man.
Heard. Mr. Mazhar Bhuiya, learned counsel for the applicant, and Ms. F. Huck, learned counsel for the respondent. This application under order 41 rule 19 of the Code of Civil Procedure is preferred by the applicants for readmission of the appeal
Here the fixed will of the journal.
You know, Piba?
number
Did you not the journal?
89 of 2019, which was dismissed for default. Higher order dated 19/3/2026. The learned counsel for the applicant submits that on account of his ill health, he could not remain present on 19/3/2026. And further, the matter was listed in the supplementary list and the same escaped from his eyes and thus and the cause of his absence has duly been explained in paragraph number 13.
Yes, ma'am.
In which paragraph you have mentioned it?
I have mentioned in my paragraph 3, 4,
3, 4, and 3
and 5, ma'am.
3, 4, and 5. 3, 4, and 5. And therefore, he has contended to allow this application and to restore the RSN number 89 of 2019
RSN number 89 of 2019, ma'am.
to fix the matter for hearing. The learned counsel for the opposite party submits that she has no objection as the application is filed within the period of limitation, and the matter may be listed for hearing. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. RSN number 89 of 2019, which was dismissed for default, file order dated so and so, stands restored to the file. SSL list the RSN number 89 of
89
2019 for
2019.
hearing. First observe.
নহলে summer vacation ৰ পাছত দি দিয়ক। July.
Oh, much obliged, ma'am. 50, ma'am.
16 Thursday.
Item 27.
My lord, this IA has been filed with a very limited prayer, my lord. You know, the IA that has been, my lord, to file in 37 RSA, my lord, 25, 26, which is in dispose of. The matter was, my lord, lordship was taken on 7th, and that was, my lord, disposed. But the copy of the order was, my lord, available on 21st of this month, my lord, in the online. So after that, my lord, I apply. But as my lord, after when I have seen that this, I have lost this case. So I wish to try my luck.
When did you receive the certified copy?
It is received on, my lord, yes, 22 for, my lord.
Hmm.
So I
So
required,
from
my
which
lord,
date the limitation will start?
but it is 90 days, my lord.
Pardon?
90 days limitation is there to go to, my lord, SLP, my lord.
Then why this application?
My lord, because, my lord, I have to pick up, because I was a plaintiff in the bolding cases, my lord, in the lost, in the title suit as well as in appeal, my lord.
Hmm.
So, my lord, at any moment, my lord, execution may start. So this is my prayer, my lord, there's at least, my lord, at least 8 weeks. I prayed, my lord, that by this time I can approach before the last court. This is after that I have no any way to go, my lord. So this is only prayer that can be, my lord. Only till then, my lord, the suspension of this lordship order. my lord. I applied on, my lord, immediately on 22, and copy was also obtained on same day, my lord. Because, my lord, here the execution case is not necessary to be instituted, so they can come in straight away.
So whether this order 42 rule 2 will be applicable here.
Well, there is no other provision, well, I have searched, my lord, but if there is provision, my lord, the lordship has the power to, my lord, to suspend the order till, my lord, facilitating to file the, my lord, proper petition before the proper court, my lord. That can be, my lord. There is no any such provision, I have searched, my lord. But the Supreme Court, I have searched many cases, my lord, it is there, that lordship can pass the order, only for suspension, temporary suspension.
You
my lord.
saw any order?
My
if
lord,
available,
I have
sir.
searched in the Google, my lord, that is when the provision is there. But the lordship, my lord, I exactly, my lord,
You produce the order, we'll see. Because otherwise, this will go to the Supreme Court.
Nothing will, my lord, hamper, my lord, because, my lord, the
No,
lordship has-
tempering that does not arise, but the question is whether this court has the power.
But lordship has the power, my lord, because when in
No,
lower
you
court,
show the power,
in lower
you
court
show-
also, my
you
lord, this
show the
sometimes,
provision.
in the lower court also, in sometimes this happen, my lord. The some order has been passed, we pay for the extension, so that time is always granted. At
No,
least for
I'm
my-
not adverse in granting any time to you, but you show me the provision.
No, my lord, there is no any specific provision.
You
I
show,
agree.
then
But
you
the
show
court
the
has the
Supreme
power.
Court judgment.
Court has the power, my lord. They extend
You
this,
show the Supreme Court judgment will.
the Supreme Court judgment is not there, my lord. I have gone through the, my lord, the website, then it is saying the certain provision
No,
court has done. But
then Mr.
that is only to
Mohanty,
be High Court concern, that they
No,
have to be
no.
done, not by the Supreme Court. Only my prayer, my lord, a limited prayer, at least, my lord, from the 1st of June, the holiday of the Supreme Court will be started. So I will be filed, my lord, before 30th of this May, my lord. So I am preparing everything, but only to that extent, so that, my lord, my entire, my lord, exercise might be futile if the lordship, my lord, I will be evicted by this time. This is only,
No,
my
no,
lord.
no. You show any provision or any decision, this court will take a call upon it.
But they, my lord, I have searched in Google, my lord, this is a already, my
You
lord,
show
discussed.
whatever provision or
But the
any
no
citation
specific
is available.
judgment is there, but in lower court
Then
also, but the same
Mr.
practice is always there, my lord.
No, then Mr. Mohanty, this court will not be in a position to help you.
In criminal case also, my lord, the
No,
conviction.
this is not a criminal case,
My lord,
please.
only that my prayer is
Sorry.
very limited, my lord.
Sorry.
Only for 4 weeks, my lord.
We'll take it up at 2 o'clock. In the meantime, if you,
Then, my
Find
lord,
anything?
tomorrow, my lord, I'll show you the provision. my lord.
okay. On the affair being
Let's see
made by
tomorrow.
Mr. Mohanty, Procedural is the matter tomorrow. Okay.
But there is no specific provision in the CPC, my lord. I have gone through.
No, maybe if
Yes,
there is any decision of any court, you produce it.
I'll try. my lord.
Items for additions. Item number 2.
Okay, I am aggrieved by an order by which
Item
two
2, admission.
admission. I am aggrieved by an order, Your Lordship, by which number 2. PRP 7.
Item 3.
I'm sorry.
May I please, Your Lordship?
Hmm.
Lordship, may I kindly pass over the matter for the day, Lordship?
Why? Why?
Lordship may fix it for hearing, Lordship.
Interim order is there. Your
There is a interim order, Lordship.
may fix it.
On the request made by Ms. Afok, learned counsel for the petitioner, this matter stands adjourned for the day. The learned counsel for the respondent submits the interim order passed earlier. May be allowed to continue. They are allowed.
The date will be.
Interim will continue.
15.
Item 3.
Sorry, Your Lordship, I miscalculated.
No problem.
Lordship, in this case, the impugned order, amendment was rejected. Prayer for amendment was rejected, Your Lordship. The plaint before amendment is at annexure 1, page 14. It is a partition suit. So partition suit under Mohammedan law, all the parties, including the defendants also, are entitled to some share. So plaint starts from paragraph page 14, annexure 1.
Where is the impugned order?
In Lordship, before going to the impugned order directly, Your Lordship, just 2 minutes.
Hmm.
At paragraph number 6 of the plaint, which is at page 16, the plaintiff has enumerated all the shares entitled by the plaintiff number 1, plaintiff number 2, as well as the defendants in paragraph 6, page 16. Paragraph 6 of the plaint. And your lordship, in the prayer portion of the plaint, only the plaintiff prayed for his own share, declaration of his own share. So by way of an amendment, which is the amendment petition is at annexure 3, your lordship, at page 23.
So there's plaintiffs and the defendants, their brothers and
Brothers and
sisters.
sisters. Lordship. So everybody
So
is
the
entitled
suit
to
was
some share.
partition suit was filed by
One-
5 brothers
Right.
and sisters.
Some brothers.
Yes. Thereafter,
Thereafter, your lordship,
the
In-
trial court has granted partition.
no lordship. During the suit, after the PW stage, the PWs were filed, cross-examination was not there. We prayed for an amendment, your lordship, of the plaint. That was rejected.
Where
So-
is that petition?
Amendment petition is at annexure 3. It
Page
is at
number?
page 23. In paragraph 4, the necessary amendment is mentioned, your lordship, at page 24. That in page number 5 under paragraph number 14A, 14 is a prayer, your lordship. The following lines are necessary to be added. Declaration that the plaintiff number 1 and defendant number 1 and 2 each are entitled to
No, Mr. Mukherjee, you see,
lordship.
by that time you have filed the petition for amendment of the plaint.
Lordship.
The partition suit was in the stage of hearing.
No, lordship. PWs. PW was filed
Mm.
on affidavit. Cross-examination was not there, not yet done.
Maybe.
Lordship. After filing the WS, issues were framed, your lordship.
Mm.
Thereafter, PWs were filed.
Mm.
Filed by
So
me.
when the
I,
trial
the plaintiff.
starts.
Lordship, there are contradictory judgments, your lordship.
Mm.
In some cases, it is said it starts with the framing of issues, your lordship.
Mm.
When the issues are framed. And
Framing of issues.
is, and while it is also, the Honorable Apex Court is also of the view that when the evidence is laid, your lordship.
Mm.
In this
So
case,
here the evidence has been laid.
lordship, I am the plaintiff, your lordship. I filed the PWs, your lordship.
Mm.
I have not been cross-examined by the defendants as of now.
Maybe.
Now, the nature of amendment that is sought, your lordship.
No,
that
that's
is
all
what-
right. But you have to show your due diligence.
Yes, your lordship. That is
Where in which paragraph of your application you have explained it?
para 2, your lordship.
Para 2.
Para
Hmm.
2 and 3, it is specified, your lordship.
Does. Developer একটা record আছে। তাতে কালি উঠিয়ে দিছিল যে judgment তো লয়ে গেছে। ও।
In this case,
So you have explained your diligence in paragraph number 2 and 3.
2 and 3 of the petition, your lordship.
In 2, you have mentioned that due to oversight and bona fide mistake on the part of the engaged counsel.
Counsel.
And in 3,
3,
what is
the
your
necessity of the amendment is specified, your lordship.
pardon?
The necessity of the amendment, because the amendment is only in the prayer portion of the plaint, your lordship. In the
Maybe.
body of the plaint, I have specified which of the parties is entitled to what share in paragraph number 6.
Mm.
But declaration as regards to those shares was not specified in the prayer portion.
And where is the impugned order?
Impugned order is at page 30, annexure 5. In the impugned order as well, Salem Bar Association was discussed and it was held that it has to be construed liberally. However, the learned court, trial court has said that there is no averment as regards to due diligence. As such, the amendment is not allowed. I would like to rely on a judgment, Your Lordship. LIC versus Sanjeev Builders, Lordship knows this, Your Lordship. This is the judgment which,
No, that is there.
Lordship.
But the after amendment, the one proviso was incorporated.
Yes, Your Lordship. In
As per said proviso, you have to show your due diligence.
if trial has commenced, Your Lordship. If trial has already commenced, due diligence
In
has to
this
be
case,
shown.
a trial already commenced. You have the PW's evidence of PW submitted.
Has been submitted, has
Yes.
not been cross-examined.
Maybe.
So in case of Sanjeev Builders, Your Lordship,
Hmm.
until and unless the evidence is over, trial has not commenced. I am not going into that as well, Your Lordship.
Hmm.
I am relying
No,
on-
there are some decisions.
there are conflicting decisions. Your Lordship.
You take down two decisions. One is 2020 11 SSA 549 and 2009 2 SSA 409. And you come prepared and you submit the court whether in view of the finding recorded by the Supreme Court in these two decisions,
Yes.
we can allow your petition or not.
Lordship, I would also rely on 2022, the Sanjeev Builders as well, Your Lordship, on the next day.
Maybe.
But practice said that they were not cross-examined. But the order itself reflect that 5 witnesses have already been cross-examined. On the day of 6 witnesses, on the day of examination of cross-examination of 6 number of witnesses.
Where is that order?
Yes, page number 31. Page 31. One page there, another page there, half paragraph.
5 witnesses, yes.
One series and it is the defendant have already cross-examined 5 members of 24 cases in this case, and the cases which were cross-examination of PW6. In the suit, the trial had already commenced.
So, Mr. Mukherjee, you were not,
Lordship,
you seems to be not fair.
Lordship. Yes, is over. Lordship, I'll come prepared with the
Okay.
judgment.
Okay.
Whether it can be permitted after trial has commenced, that will be the issue that has to be.
Provided you have show your due diligence.
No due diligence.
Heard Mr. Mukherjee, learned counsel for the petitioner, Mr. M. Khan, learned counsel for the respondent. Heard in part, list the matter on. When? Next week?
Next week, any.
11th May,
Which of this?
item 4.
That is a lot. Lordship has passed, in this case, Lordship has passed several orders for my pay protection and Lordship emotional benefit. Lordship, in the meanwhile, Lordship, the petitioner has retired on 31/1/2026. But except the GPF money, Lordship, I have.
When she retired?
31/1/2026.
Okay.
Now, even after retirement, Lordship, they have not processed anything, Lordship. Due to non-fixation of the pay protection, Lordship, the other benefits I have not been given.
So, Madam, at what is this, the matter is pending?
Your Lordship, I have provided with up-to-date instructions, Your Lordship. This is the instructions of 2024, when the petitioner was released, Your Lordship, on 19th September 2000.
No. Have you gone through the order? Dated 9/1/2026. So on that day, one letter was produced before this court. Letter dated 8/1/2026. As per said order, said letter, the Director of Secondary Education was directed to resubmit the proposal, whether the proposal was submitted or not.
Lordship, we granted a little bit time so that I can obtain the instructions, Your Lordship.
No, I have seen you sitting here since morning. You could have go through this order.
Yesterday, Your Lordship, the release
Who provided?
from the Director's Office, Your Lordship.
What is there?
This is from the Inspector of School, Your Lordship.
Hmm.
That the petitioner, the teacher of Swarna Lakshmi HS School, Kachar is hereby released today on 19th September 2024. This is the instructions I have related.
No, release, that will not serve the purpose. The question is whether the proposal was submitted, resubmitted. You obtain instruction, we will take it up on Monday. Heard Mr. Das, learned counsel for the petitioner. Is Teranki, learned standing counsel for the secondary education department. Ms. Teranki submits that she may be granted some time to obtain up-to-date instruction in respect of resubmission of the proposal pursuant to the letter dated 8/1/2026. We are allowed to list the matter on Monday. In the meantime, Ms. Teranki shall obtain instruction in respect of the follow-up action taken by the respondent authorities pursuant to the letter dated 8/1/2026. Less than Monday.
Lordship, Monday will be holiday.
Monday?
Court. Friday.
Court may.
Court. Lordship, this matter is part heard. Lordship will keep it as part heard.
Okay, this is a list the matter as part heard.
Obliged.
Thanks for hearing. Item number 10.
Nothing, Your Lordships. Your Lordships, in this case, I have contact with my client yesterday itself, Your Lordships.
Pardon?
I contacted with my client. Client contacted me yesterday itself, Your Lordships. And he given some inputs regarding, I may file additional evidence, Your Lordships. in this case.
Additional?
Evidence, Your Lordships. So 1 week time may be given. If at all it is required, I will file. No, if not, then I will do the hearing, Your Lordships.
This is partisanship between brother and sister, Lordship.
Hmm.
So regarding source of title, that is inheritance right, that is admitted. Relation is admitted.
Hmm.
Apart from all the allegations I have met, everything is admitted in cross-examination of DW 1 and 2, that is brother, who are appellants to the suit.
Hmm.
Your everything admitted, but Your Lordships, he also admitted that the property was mortgaged to the financial institute, Your Lordships, in the plan itself.
Hmm.
And his allegation, his pleading is also there that he relinquished the property initially. So these are the things, Your Lordships, regarding in particular the mortgaging the property to the financial institute, Your Lordships. In fact, I was not in the trial. I came in the appellate stage, Your Lordships. So if some document was there, I want to place before this in board as additional evidence. Only 1 week.
No replies, no documents, nothing is there.
Here, his own plan says so.
Issues are also not there on this point, Lordship. Apart from it, in the memo of appeal, no grounds are there. So my learned
Okay,
friend raised first
since
time
this is a regular first appeal, let him avail the opportunity. Heard Mr. Enenja, learned counsel for the appellant, Mr. R. Ali for the respondent. Mr. Zha submits that there may be a requirement of filing additional evidence. And to that aspect, he will obtain necessary instruction from the appellant and a price for listing the matter after a week.
Next week, kindly, Lordship.
Next
Matter is
week.
of 2018.
We are allowed to list the matter on 7 May.
Seventh.
Must be. Item 13.
You are for the appellant.
Yes.
Respondents are available.
Actually, this matter, the appellate court, I file appeal. That appeal was dismissed on the ground of delay, my lord. So matter will
Okay.
remain back.
Correct. Decision. After some time,
Item 14.
Lags. Kindly pass out the timing.
who is your senior?
Mr. Akib.
RK Bhuya. Okay.
Some other hearing.
So you have difficulties today.
No, I have, now I have not, but after some time, I is on his face. He's on legs.
Timing.
Item 16.
But again, the respondent is not here.
Not present today.
But still not seen, my lord.
You have not seen. Is the DM not?
DM. DM not? Yes, DM. And G Rahul Prabhu. Naam reflect for response.
Okay. Contact over private. After some time.
Sometime or some other day, my lord.
As you like.
Last time they had expressed urgency, so therefore, well, anyway, your lord, I'll leave it to your lord.
Timing. He will contact the council.
Item 18.
My lord, this is a very old case, 2017, since every case we are getting good result, but they filed this and that case and our land is under their occupation.
No, this appeal is of 2022.
My lord?
Appeal is
No,
of
appeal
2020.
is 22, but the original case is 2027. 2007. So, and in.
But, I have seen Mr. MSX. You are for the respondent. You are for the respondent.
Yes, I
in
am
this
for
matter.
the respondent, yes. I am for the respondent. The thing is, this matter, they have conceived many things. I will submit for him, but last time also due to some misunderstanding, the order was taken. My junior could not say what I instructed.
Okay, I have seen Mr. Sheikh in the court today. Kobe, you contact him. Wait for some time.
Item 19.
In this case, the respondent has been expelled during the proceedings before the Honorable Court. However, the Honorable Court has also passed the directions to the registry to issue notice. I have taken the steps regarding the notice, and report has to be filed by the registry whether legal errors have been served the notice or not.
Yes. As per office note. It is a notice for her life. There is no very nice office at all. Powerful man, what of doing? So he gets about private. Step to lole. I put to hand. Kapra. Asini ke kapra material. Mr. Sharma,
Yes.
please wait for some time. When counsel earlier entered appearance, the court master will contact him. Wait for some time.
Sir, new counsel has appeared on behalf of the respondent.
No, earlier.
Early on the last to last date of hearing, the Honorable Court has also passed the directions to the respondent that the respondent should appear and file the application regarding impleading the legal head in the present appeal. However, none has appeared on behalf of the respondents. Then, on the next date of hearing, in the 12th of month, in December 2025, I've requested the Honorable Court to issue the notices because I have moved an application regarding impleadment of the legal heirs, and that was pending before the registry. So, the Honorable Court was pleased enough to pass that orders. It is on 8th of 12, 2025, the last to last, because on 27th, the Honorable bench was not sitting at that time, so the matter has been kept in abeyance.
Okay, let the counsel come. We'll see. Whether you have inquired from the section, why your application is not listed? There may be some defect.
No, I am having this received, and after
No, maybe you have filed the application, but there may be some defect for which they are not listing the matter before the court.
I will inquire just now itself, and I will inform the Honorable Court.
Okay, after some time.
After some time.
After some time.
Yes.
In the meantime, they will contact the counsel, earlier counsel.
Yes, sir.
Okay. Correct. Postal back consignment to give for a government. এবার পরিবেশনে মানুষজন দিল্লি पर आएगा Lordship, I am for the respondent. Appellant normally in all dates remain absent, Lordship. In order columns also, some of the dates he remained absent. Item number 29.
Supply list, Lordship.
Yes.
And for the respondent. 2 and 3.
A. Rahman. No, on previous occasion, he was present. 26/3/2026.
25/11/24 if not present, 14/2/25 appellant, 22/6/25 non-appeared, 28/7.
No, this year on 9th of November 2026 and 26th of March 2026, and the counsel for the appellant present. None appears for the appellant on call. However, Ms. R. Sodore, learned senior counsel, assisted by Ms. So-and-so, present. Ms. Sodore, learned counsel for the respondent, has pointed it out that conduct of the appellant appears to be not at all satisfactory as he remained absent on 6/11/2025. (28/7/2025).
2/6/2025.
(25/11/2024). Be it as it may, unless the matter after a week, in the event of subsequent non-representation of the appellant, appropriate orders shall follow. After 1 week.
Pending items.
After 1 week. Hearing. Okay, reference number 2 is observation.
On 26.
After 1 week. After 1 week. After a week.
If they remain absent, I will dismiss it.
7.
Apply.
Pending items, item 14.
May I please, Lordship?
Yes.
Lordship, this appeal against the concurrent findings.
Mm.
Concurrent findings what happened, Lordship? That the appellant as plaintiff filed a suit seeking declaration of right side interest and confirmation of possession and for injunction in respect of Schedule E length. And in this said suit, the respondent side as defendant, they filed their written statement and counterclaim seeking the declaration of right side interest and recovery of possession in respect of the land described in Schedule Y. Their claim was that that Y land is 17.5 acres is a part of Schedule X land. So accordingly, the learned trial court, Your Lordship, my suit has been dismissed, holding that I could not exhibit because my claim on the basis of a deed, gift deed executed by my father, that is Exhibit 5, and my father got the land, Hyde Exhibit 4, that is by way sale deed. So even then, the learned trial court held that the attesting witness we have not examined. So that is why my right title has been discarded, and counterclaim has been decreed partly, holding that though they are claiming 7.5 acres of land, out of that land, the decree has been passed in respect of 1 katha of land. So that is why their counterclaim partly decreed and my suit has been dismissed. So against that, your lordship, the appellant before lordship, they preferred an appeal before the appellate court. Interestingly, appellate court, by this judgment, your lordship, it has been held that yes, this judgment and decree is liable to be interfered. Is liable to be interfered on the issue of non-gender parties, necessary parties. Liable to be interfered and it is to be remanded. So accordingly, the learned appellate court remand the matter, but by the death judgment, dismiss my appeal. If the appeal is remanded, the appellate court is to set aside this judgment, entire judgment. But is the holding that yes, it is to be reversed. But reversing order as observation is there, but instead of that, one additional issue has been framed, remanded the matter to the learned trial court regarding only whether the suit is made for non-gender necessary parties or not, and parties are directed to lay evidence in this suit before the trial court, but dismiss my appeal. Now, what will be the consequence, your lordship? If the appeal is dismissed, then the other findings, it will go against me. And what is to be remain to be decided by the learned trial court after remand being made. So may I read out the lordship, the judgment of the appellate court. Lordship, paragraph number 29 of the appellate court judgment, page 103, your lordship.
Yes.
Lordship got 29. However, by way of amendment, Siri, Sarvajanin, Kalibari, Durgabari, and Sarat Smriti Sangha is made party, but both Kalibari, Durgabari, and Sarat Smriti Sangha are juristic persons only, and it is the statutory law that the juristic person is to be presented by a rational legal person, and both Durga Soenso and Sarat Smriti Sangha are religious institutions, are represented by their president and secretary. But neither the president and secretary of both the Durgabari, Kalibari, and Sarat Smriti Sangha are made party in this suit, and without their presence, Durgabari, Kalibari, and Sarat Smriti Sangha remain unrepresented, and as such, no decree can be effectively be executed. Hence, Durgabari, Kalibari, and Sarat Smriti Sangha are the necessary parties of the suit of the plaintiff appellant, which have been assailed by the defendants at the trial stage, but the plaintiff, although amended the plaint, but failed to make President Secretary of the Durgabari, Kalibari, and Sarat Smriti Sangha as party in the suit, and without their presence, no effective order can be passed, which the learned court below overlooked. As such, the said judgment of the court below deserves interference, and accordingly it is interfered by by holding that the suit of the plaintiff is not maintainable in the present form, and on this count the judgment and decree passed in so and so required to be reversed, and accordingly it is reversed. For para 30, lordship, for the aforesaid reason, the decision arrived by the learned court below is found suffers from irregularities and infirmities which needs interference, and accordingly it is interfered, and the decision arrived by the learned court below without the presence of so and so deserves reversal, and accordingly it is reversed. As such, further discussion under the hand of other heads would be redundant exercise only so no further discussion is made. Paragraph 32. From the above discussion, it follows that the appeal is devoid of merit, which requires to be dismissed. Lordship, on the one hand, court held that it is to be reversed, and unluckily it is reversed. But in paragraph 32, your Lordship, it is held then an appeal is devoid of merit, appeal is dismissed. We, the appellant plaintiff, prefer the appeal. Neither respondent nor dependent, they have not preferred any appeal against the partly decreed to counterclaim. Only appeal was preferred by me. If the appeal is dismissed, what remains to be lost? That is to be rectified, your Lordship. I am not on that matter to be remanded. Yes. If the appeal is dismissed,
Mr. Hawk,
It cannot be, once it is dismissed and on other way it is remanded.
yes.
Okay. It cannot, never.
No, in which line it is remanded? Which paragraph?
33.
33, 30,
No, 32.
32 it is.
32 is
32 is
dismissed.
dismissed. That
What?
remand matter, remand?
Order, your Lordship, in this conclusion, the decision of so and so, the court of so and so, and remanded the case. 33, your Lordship, order portion.
33.
Okay.
That should have been allowed. It's not in place of dismiss procedure.
Yes.
Okay. The parties have to appear before the appellate court on,
What, in the month of May, Lordship?
we'll fix the
Any-
date.
Lordship, any day.
When? After 15, within 15 days?
15 days, Lordship.
Appellate court or trial court?
Appellate court, bottom appellate court.
May 15?
May 15, Lordship.
Okay.
Lordship, obliged.
Starting at the 30.
My lord, actually, in this case,
Yes.
so actually, my title suit was dismissed. Thereafter, we file an appeal, and there is a delay in filing the appeal. We file a condemnation petition. That petition was dismissed, and accordingly, appeal has not been admitted. Appeal also can see annexed to page 5 is the impugned judgment, impugned order, passing Miss case number 115/2017. Only a ground of delay, the appeal has not been admitted. Please, now this honorable court, same charge. So the Sukadisi, since the appeal has been dismissed, not decided by the appellate court on merit. Now this honorable court can charge substance question of law. So this is the appeal here on merit on the basis of judgment rendered in title sheet number. So now there is two way now. Since the appellate court has not had the appeal, it was dismissed for default. So it may be remand back. They have the appeal on merit.
No. There is at least 2 or 3 decision of the Supreme Court
Yes.
where it is stated that though the appellate court has not discussed the evidence or other
yes,
materials,
merit.
yet the appellate court has affirmed the decision on merit.
Merit.
And in that view of the matter, this court has to ascertain the merit of the case also.
Because appellate court not decided the appeal on merit.
Therefore, this substantial question of laws have been kept.
Yes. If let's say decided on merit, I have
You argue the matter on merit.
yes. Now Lordship kindly see the plaint. My case is this, my lord. Page 31 is the plaint. You also got it, page 31.
Page number?
31. Because I want to draw lots of attention. My facts, case of the facts on in the stated in the appeal mail. Now plaint. It looks like the paragraph 1 paragraph 1. That a plot of land measuring 4 bighas, 4 katas, 11 lesas of land comprised with periodic patta number so covered by tag number so and another plot of measuring 4 bighas so comprised periodic patta number so covered by tag number so zero at village so now that a plot of land measuring 4 bigha, 4 kata, 11 lesas of land comprised with so covered by tag number so is described in Schedule B. Is the sweet land. Again, another plot of measuring 4 bigha, 4 katas, 10 lesas of land comprised with PP patta number 170 covered by tag number so is also the sweet land described in the Schedule C. The schedule land originally belongs to one Josuda Lal Rai, who had been possessing the sweet land peacefully during his lifetime. The said Josuda Lal Rai had sold the total A schedule land to the plaintiff by dint of registered sale deed number so dated so and accordingly delivered possession of the sweet land to the plaintiff. Accordingly, the name of the plaintiff had already been mutated in respect of the sweet land on so. The plaintiff has also been paying the land revenue of the land regularly, but the name of the plaintiff was cancelled as shown in Jawamandi number so, Dag number so, without any specific order. This is the main fact. The plaintiff is an illiterate man and has been suffering from mental disorder for a long period, so he was unable to cultivate the land. As a result, he had happened to adi the A schedule land to one Abdul Kasem, Abdul Qudus, Baharul Islam, Shahjamal Mandal. Accordingly, they have been giving share of the crops of the A schedule land regularly. But in the meantime, Shahjamal Mandal died. His legal heirs, defendant number 10, 11, 12 have been possessing the C schedule land as Adia. Again, the plaintiff had given Adi of the land as mentioned in Schedule B to Abdul Qudus, Abdul Kasem, Sher Muhammad Baharul Islam. They had been possessing Schedule B land as alia. In the meantime, Said Abdul Quddus died, leaving his legal heirs Mahabar Ali, defendant number 4, Abdus Ali, defendant number 5. But suddenly the defendant had denied to give the crops of the land of the sweet land to the plaintiff. Then the plaintiff have approached the defendant to clear their due share of crops as accrued from the sweet land. But the defendant have been taking some other pleas. The defendant lastly on 2/5/12 had denied to give their share of crops to the plaintiff as accrued from the sweet land. Even the defendant had stated that the sweet land lands their own land. They had purchased the land from the original patadar and they had already mutated their name in this of the sweet land, so they would not vacate the sweet land in future. The plaintiff had rushed to the office to inquire the record of land where he could know on so and so about the illegal mutation of the defendants in respect of the sweet land. The defendants have illegally and forcefully possessing the sweet land. If the defendant had purchased the sweet land by any registered deed from the patata, then that is false and personification. Because the plaintiff had already purchased the A schedule land from the original patata earlier than if any deed of the defendant. So the defendants have no right title so. That the plaintiff also could know from the records that the name of the one Khuza Mandal also mutated in the sort of B schedule land. But Khuza Mandal had neither purchased nor in any other way had able to obtain the B schedule land. So his name was illegally mutated in respect of schedule B sweet land. His name is to be cancelled, declaring it null and void and inoperative in law. Again, the mutation name of so Shirley Swenso and Sensu is illegal and to be cancelled, declare null and void and inoperative law. The name of one Idris Ali was mutated in respect of the C schedule land as shareholder by order dated Swensu, but the said Idris Ali actually was not the shareholder of the plaintiff in respect of the Schedule C land. So this mutation is illegal and to be cancelled, declaring it null and void and inoperative law. The plaintiff had purchased the total A schedule land by registered deed number so. So Idris Ali was not entitled to become patadar of Schedule C land as shareholder. Again, the mutation of Sajamal Mandal and Sagar Ali by orders that are illegal and are to be cancelled, declaring it null and void and inoperative law. Again, the mutation order of so Bagurigere Pathar Darul Ulama Islamia Madrasa is illegal and liable to be cancelled, declaring it null and void and inoperative law. The illegal mutation, the name of Baharul Islam and by order the census. The plaintiff had neither sold nor transferred. You also can see that is very important. The plaintiff had neither sold nor had transferred the sweet land to anybody else during his lifetime on the basis of the opportunity of disorder of the brain of the plaintiff. The defendant had mutated their name on various that illegally with the influence of the revenue authority, but the defendant have no right title interest over the sweet land. The defendant had illegally and forcefully entered the sweet land. So the defendant are now mere trespasser, but the plaintiff have right title and interest over the sweet land. In order to substantiate his right, the plaintiff has been completely sweet. So this is the fact in our case, my lord. Now it logically see.
What is the written statement?
Written statement I am searching. My lord, record has come. I have record. My lord. Yes, my lord. কবে আসছেন দেখে একটা কবে আসছে কবে আসছেন এটা কবে আসছেন এটা কত কবে আসছেন Yes.
Evidence के लिए है ये कौन ये ये तो ये नहीं
কতগুলি এটা করি
yes
Their main contention is started from paragraph 14 of the written statement. That at present, age of the plaintiff is about 57 years, and accordingly, in the year of 1965, when the plaintiff claims to have purchased the land, Schedule A, he was a minor child of age 9 years. Actually, it is his father, Dan Muhammad, who, with his own money, purchased the land in Schedule A in the name of eldest son, Firdaus Ali, who is the plaintiff, my lord, out of love and affection. When the plaintiff Firdaus died, Ali did not have any income of his own, and at that time he was a minor boy of 9 years. Dan Muhammad Mandal purchased the land of Schedule A for the maintenance of and livelihood of his family members. Such practice was a popular practice in those days to purchase any property in the name of his or her eldest son. At the same time, in those days, the year of 1970, there was no prohibition to purchase landed property, Benama, in the name of his eldest son, in as much as the Benama Transaction Prohibition Act was in force. Later, in his lifetime, Dan Muhammad Mandal gifted the land in Schedule A verbally in favor of his son Khoka Mandal and Idris Ali under Islamic law by declaring such gift to all concerned by putting the land under KP Patanava Sensu in the exclusive possession of Idris Ali and the land under KP Patanava Sensu in the exclusive possession of Khoka Mandal by exercising his power and position as the real owner and got the land mutated with Idris Ali and Khoka Mandal on Sensu. Accordingly, in KP Patanava Sensu of village Sensu, the name of Idris Ali was mutated in place of the plaintiff Firdaus Ali by the order dated Sensu. And likewise, in KP Patanava Sensu, village Boguriguri Patar, the name of Khoka Mandal was mutated in place of Firdaus Ali by the order dated Sensu. Unfortunately, in the Sodar Jamabandi, maintained in the office of the Deputy Commissioner Parvata, mutation order dated Sensu in favor of Khoka Mandal passed in KP Patanava Sensu has not been entered on account of accidental error and omission, but the mutation note is still there in the Jamamandi maintained in the office of the circle officer for that Khoka Mandal sold 2 biggest cutters of land, 10 lessers of land in a plot within Dagnava Sensu under Sensu at Boguriguri Pathar in favor of this is Pathar of the Sensu, namely Sensu. Sensu, and defendant number 1 and 2 against receipt of valuable consideration by executing registered deed number Sensu. That again Kuka Mandal sold rest 2 bighas of 2 katas 1 lesas of land in a plot within Dag number Sensu, Kepe Pata number Sensu, draft defendant number 1 and 2. Village Bogri Pathar in favor of the deceased against the receipt of valuable consideration by executing a registered deed number Sensu and deliver position. That on the other hand, the initially gifted 2 bighas land within Dag number Sensu, village Bogri Pathar in favor of Bogri Dalul Ulum Islamia Madrasa by executing and registering deed number Sensu and delivered position of the land. That the further initially sold 4 katas land in a plot of within Dag number Sensu or village Bogri Pathar to defendant number 10 and deceased father of the defendant number 11, namely Shahjamal Mandal, again receipt of valuable consideration by executing registered deed number Sensu and delivered possession of the land. That again, initially sold remaining 2 bighas of land in a plot with Dag number Sensu and the KP Patta number Sensu at village Bogri Pathar in favor of the defendant number 2, receipt of valuable consideration by executing and registering deed number Sensu and delivered possession of the land. In the manner stated above, in his lifetime, Khuka Mandal transferred entire Suban land covered by Dag number Sensu, KP Patna Sensu, and Bogri Pathar. On the other hand, in his lifetime, Idris Ali transferred entire land, residence Sensu covered by Dag number Sensu, Bogri Pathar. The defendant are bona fide purchasers. This is the case. This is the case. Now question, my lord, that whether they have a sellable rights, whether I am the my father, it is their allegation that my father passes name in my name. Rightly, wrongly, I am the owner, I am the purchaser, my name mutated, and without passing any specific order, my mutation order has been cancelled. Now they show that they passed that bill done. To non-challenging those deed, that is why subsequent question of law has been framed. Learned trial held that since I have not challenged those sell deed, so we lost our right title interest with land. So that is why this subsequent question of law has been framed. Whether my right title interest has been extinguished for non-challenging the right title, challenging the registered sale deed, and this is the subsequent question of law. Non-challenging the registered sale deed. Executed India 1981 and allowing the defendant to remain in possession of the sweet land. It is subsequent question of law 2. So in this connection, my lord, so since I am the owner, I am the purchaser of the land, so if anyone sell the land to other person by fraud with the revenue staff, that deed is not necessary to challenge because that is automatically lose the force, my lord. They are not cannot hold the field. If this court held that I am the purchaser, I am the owner, then no one can sell it, and that deed is not necessary to challenge in every case, as my lord. That is why now subsequent question of law is loss of condition 1. Whether the court below was justified in dismissing the suit of the plaintiff on the basis of that the plaintiff's right over the suit land stood extinguished and time barred without there being any materials on record to show that the defendant claimed adverse position against the plaintiff. This is a question of law, and now we lost the judgment of the trial court. The finding they held that time so it is time bar. It is start from my page 9. Page 11, my lord, issue has been framed. Whether there is any cause of action for the suit, whether the suit is barred by limitation, whether the plaintiff has right title interest over the suit land, whether the plaintiff is entitled for a relief claimed, and to what other reliefs the plaintiff is entitled to. The
So
plaintiff
issue number
examines,
issue number C is the material issue.
yes, whether the plaintiff right title interest over the suit land. Now, the learned court below, my lord, in issue number B, held that the suit is barred by limitation. But my specific case is that we came to learn about the mutation in the year of on 15/1/2013. And we immediately after commission we filed a suit. So there is no delay in filing the petition. So far as issue number B is concerned. And learned court will have wrongly held that suit is barred by limitation. In my plaint, we specifically mentioned the date of knowledge, and immediately after come to date of knowledge, then we filed a suit, my lord, in the 2013 itself. We filed a suit on 12/3/13. We came to learn about the mediation and the thing on 15/1/2013. So there is no time bar. Now you also can see the issue number C discussed. The issue number C.
Yes.
Now let page 13, issue number C. This issue relates to the question of title of the plaintiffs upon the suit land. The plaintiff's claim title upon the suit land by virtue of registered seal date number so, which was executed in his favor by the original purchaser. So question of passage in the land, my father in minor does not arise. I may be a minor if it is held that in the written issue they stated that at that point of time the father can possess land in the name of minor, then minor also can possess the land. Minor also can possess the land, not necessarily that father passes the land in name of the minor. This is the thing, my lord. Now, upon the suit land by virtue of registered seal date number so, which was executed in his favor by the original purchaser. It is nowhere mentioned in the deed that my father has possessed the land in my favor. Nowhere mentioned. The plaintiffs as PW1 exhibited the sale deed. PW1 also exhibited the certificate copy of the government of the disputed patta as exhibit 2. The note dated so shows that the name of fiduciary was mutated in place of original patta over the entire patta land. So nothing wrong has been done by the revenue authority by mutating my name. The defendant, on the other hand, claimed title on the basis of certain sale deeds which were executed by brothers of the plaintiff. Can my brother sell my land, my lord? Cannot. This is the one point, my lord. Another point. Vice Khoka Mandal and Idris Ali. The plaintiff claimed that the defendants were mere permissive positions, but subsequently they disputed the title of the plaintiff. It can be said from the above discussion that the plaintiff by virtue of sale deed had title to the suit land. With regard to the gift of the Schedule A land by the father of the plaintiff in favor of his brother, the said transfer is doubtful as because it was the plaintiff in whose favor Schedule A land was sold by the original purchaser, and as such, Dan Mahmud did not have any right to transfer the land. The plaintiff stated in his plaint that the defendant disputed his title on so and so, and only after then he came to know about the illegal mutation entries made in favor of the defendant. But while discussing issue number B, it was seen how now the plaintiff, having knowledge of the register's deed number so and so executed in 81, failed to challenge the same within time. And it is the learned court below held that that is why the Swedish barred by limitations, because I am not challenged that held it within time. It is also surfaces from the cross examination of DW1 that the defendants have been in possession of the Switzerland since 1979, even if the genesis of that position may not be lawful, as Dan Mahmud did not have any right to transfer the Switzerland, but subsequently, due to specificity of the plaintiffs in challenging the deed within time, the title of the plaintiff over Switzerland has extinguished a time bar. This is the, my lord. It cannot be, my lord. So, learned trial court has wrongly held and wrongly decided that issue, my lord. Cannot, my lord. My brother cannot sell it to other persons, and if anyone passes it from my brother, it automatically be quashed. It automatically declared as null and void. No need to challenge, my lord, because I purchased my land, I established my title by executing my sale deed, and my name has also mutated over the Switzerland. Now, it is also surprising that the plaintiff has failed to challenge the deed by virtue of which the defendant claims to have title over the Switzerland. It is a settled law that there is a presumption that a registered document is validly executed. A registered document, therefore, prima facie would be valid in law. As the plaintiff has claimed that the mutation entries of the defendants of the Switzerland, which the defendant got by virtue of registered, these were illegal. Hence, the plaintiff ought to have challenged the said deed, but the plaintiff has not made to any other. No need to challenge those deeds, my lord. Because of non-challenging those deeds, my right title cannot be extinguished, my lord.
No, mutation was done on the basis of those sale deeds.
Those sale deed is illegal. If from the reading of the entire facts, it has come to the knowledge that
Maybe, but
that
there
sale
is no
deeds are
sentence
illegal,
for
my lord.
that sale deed.
Because my sale, I am not sale. It is their pleadings, it has clearly proved that I am not sale. My brother transferred. How, my lord? This is sufficient. No need to challenge those subsequent deeds, my lord. I am, if I have transferred, that is another thing, my lord. Now, my lord, the learned court below should not discuss the entire evidence on record, my lord. Their evidence has not also been discussed. Not a single whisper. The evidence of the PWs and it is not discussed. Simply held that since I am not challenging those sale deed, I lost my title.
No. Here it has been held by the trial court that the unchallenged registered document would prima facie valid in law. And there is always a presumption that the registered document is validly executed.
My lord, maybe someone may execute a registered deed. It does not mean owner of the land has executed a deed. Anyone may, by forging the signature or forging by personation, they may execute a sale deed in favor. It does not mean that since I am the partaker, I am the registered owner of the lands, my title has gone. I cannot lose my title because I am not sold the land. It is a specific case. They also stated that my brother transferred the land. I am not. Whether my registered deed executed me illegal?
No, may
They
not
can-
be,
they
but
challenge-
it was executed by your brother.
Oh, yes. That is why it is illegal, my lord. Or whether registrar did executed by the original party in my favor is illegal, my lord. Whether it is illegal, they are not questioning that deed, my lord. They simply say, my father passes the land in my name. Whether they challenge that deed, my lord. How can my brother sell the land, my land, my lord?
Whether
Sufficient.
that deed was exhibited before the trial court.
My lord?
That deed was exhibited before the trial court.
Yes. Exhibited.
Exhibit number.
Yes. Exhibit number 1. That is exhibited, my lord. Philosophically, see. My lord, page 13. The issue relates to question of title of the plaintiff among the sweet land. The plaintiff has page 13, my lord.
1-3
1-3
of this appeal.
Yes. Issue number C. Right.
Yes.
This issue relates to question of title of the plaintiffs among the sweet land. The plaintiff has claimed title among the sweet land by virtue of registered sale deed number so and so, which was executed by his favor by the original partner. The plaintiff exhibited the said deed. Exhibited the said deed. Petition 1 also exhibited the cited copies of disputed partner land. Exhibit 2. The note of the so-and-so showed the name of the fiduciary was mutated in place of the original partner over the entire part of land. So I exhibited that deed, my lord. Their written statement, they stated that my father passes the land in my name. Can it be tenable, my lord? There's mere statement, my lord, without any proof, without any supporting evidence. Philosophically, see, page 16. This is a plaintiff exhibit. Exhibit 1 is the sale deed so and so. Sideward copy Jawabandi. And sideward copy Jawabandi partner number so and so. Revenue received.
So this exhibit 1, it is available on the record, but it is a Xerox copy. It is not
I
at all
think that
legible. Do you have?
scene is in original. I have not original. It is exhibited after producing the original, I think.
Mr. Soma, do you have this exhibit one copy? No. Okay.
Photocopy is there. Read.
Photocopy, that's all right. That is also on the record, but it is not legible. Same.
My lord.
Can you prepare one typewritten copy from this?
No, then I can call it. Original copy I can call.
Original.
My lord.
Okay. Then let us keep the matter as part, Mr.
And yes, I think original maybe their hand. They have taken the original copy.
Yes. Do you keep this copy with you? And if it is not available with the party,
Then I
then
accept
you
it.
get a copy of this. So there is one sell deed in favor of you.
This is
And
the
that
main
number is 1011 of 65.
65.
65.
And by which I claim title. Right title. By virtue of this held it, I claim the right title interest. And by virtue of this held it, my name has been mutated. And suddenly my name has been disappeared from the record. Judgment copy. Without any order, without any specific order, and their name has been mutated. This is the case.
Heard Mr. J. Ahmed, Learned Counsel for the appellant. Mr. S.C. Sharma, Learned Senior Counsel, assisted by Mr. Bordas, Learned Counsel for the respondent. Heard in part. This is the matter. Covered. On next that, Mr.
36,
Ahmed, Learned Counsel for the appellant, shall produce the original copy of the exhibit 1.
I mean, item number 16.
Matter আসলে এই তো physical matter.
There.
एक minute.
I mean, item number 19.
Mr. Cabra, are you still the counsel for the respondent number 1 and 2?
They have not sent the wakalat number. The legal has not sent the wakalat number.
Okay. Can you obtain instruction?
Definitely.
So you said the counsel is coming from Delhi.
Yes.
So when you will be able to obtain instruction? Can you obtain instruction today? We'll take it up in the second half.
Regarding what?
Regarding the steps. Okay.
Yes.
I'll take the steps.
Let him obtain instruction whether he can enter appearance from on behalf of the legal heirs.
Yes.
We'll take it up at 2 o'clock.
Yes, sir.
In the meantime, he will obtain instruction.
My application will then will be entertained and next date be given.
Yes.
Okay.
Okay.
Highly obliged.
That will be.
Item number 16.
Wait, please.
Yes.
Lord, should I continue or will your lordship?
Yes. Yes. 15 minutes.
Lord, this is my appeal against a decree for specific performance, Lord. The suit was filed by the respondent. This is in respect of a apartment, Manoj, which I had constructed, the defendant number 1, on the land of the defendant number 2, Manoj. So it's a residential unit at a apartment building called Green Heaven, measuring near about 950 square feet, Manoj. Now, before I take your lordship to the pleadings, my lord, may I show the main document, that is the agreement for sale, that your lordship finds at page 39.
Yes.
Now, Jupiter Construction, that's the defendant number 1, appellant, my lord. And the buyer, my lord, finds Mr. Shoshi Mohan Das. He's the buyer and the plaintiff, my lord. Now, I'll just quickly refer to a few relevant clauses of the agreement, my lord. First, if your lordship has clause 3 at page 40. The purchaser, second party, also agrees. Clause 1 is the consideration amount. And clause 3, your lordship finds the purchaser, second party, also agrees that in the event of the first party being required to pay or deposit any amount with the municipal corporation, central or state government, or other authorities for and on account of betterment charges or development taxes or payment of similar tax fees, the same shall be paid by the second party to the first party proportionately, and in determining the proportion, the decision of the first party shall be final and binding. So this is over and above the sale consideration, which was somewhere around 28 lakhs. Now, if your lordship sees clause 6 at page 41, I'm just indicating the clauses which I believe have a bearing, my lord. Clause 6, the second party further specifically agrees that in case he cannot make the payment as per schedule above, the agreement becomes void. The first party shall have the absolute right to book the said residential unit on as is various basis with another purchaser without any objection whatever from the second party. 10% of the booking amount or rupees 20,000, whichever is higher amount, will be deduced as administrative cancellation charges, and the same shall be refunded without any interest to the second party only after the agreement with the new owner. So in case he fails, my lord, I deduct a sum of 10% or 20,000 rupees, whichever is higher, and I'll refund the other remaining amount without any interest. So there's a clear bar against claiming interest. Then clause 12 again, it says on that same page, my lord, the purchaser hereby agrees that as long as the residential unit with the said building is not assessed separately by the municipal authorities, he would pay the proportionate share of taxes assessed with respect to the building. Such proportion shall be determined by the first party on the basis of the area under occupation of the purchaser, and the purchaser will not raise any objection towards the same. So this is another additional expenditure in respect of municipal dues. In clause 17 at page 42, which in my respectful submission is important, this reads as, my lord, that the purchaser second party shall not be entitled to make any act, deed, or thing in respect of the residential unit, it being clearly understood that all acts, deeds, or things in respect of the residential unit shall be done only by the first party builder until it is handed over to the purchaser. So if I've understood the clause correctly, my lord, I carry out the entire constructions, etc. And the buyer cannot step in unless I hand over possession of the flat to the buyer, my lord. Now, on similar lines is another clause at page 43, my lord. That is clause number 25. That extra payment must be incurred by the purchaser second party against the extra additional modification work subject to the prior consent of the first party, that's the builder, and will be executed by the first party only. And regarding the same, the purchaser, second party cannot raise any objection. So 17 and 25 read together, my lord, basically says that I will be at the helm of affairs. I'll do the entire construction, modification, etc. And until I hand over possession, you cannot make any changes. And even if you were to incur some, if you were to do some additional modification, that also I will only do, and you will merely bear the expenditure or the additional cost. So this is the agreement, my lord. Now, if your lordship has the plaint, my lord, the plaint your lordship finds at page 12. I'm sorry. Now, my lord, in the plaint at page 16, paragraph 4, the details of the apartment and the consideration value is shown. So it's 950 square feet and the consideration amount is 28,50,000. As your lordship found it at page 16, my lord, paragraph 4. Now, if your lordship comes over to page 19, my lord, here they've given the details of the payments that they have made as per them till the filing of the suit, page 19. So out of that total amount of 28,50,000, they claim to have made a payment of 25,102,290. So perhaps a balance of close to 3 lakhs was pending, according to them. Now, clause, I'm sorry, page 21, paragraph 9 is important, my lord. Now, this says that the agreement dated 24/4/2012 stipulates a condition that the residential unit in Green Haven shall consist of amenities described in Schedule B in the agreement, along with some option for modification of amenities. The clause 25 of the said agreement also lays down that extra payment will be incurred by the purchaser, that is plaintiff herein, against extra additional modification work subject to prior consent of the first party, that is the defendant number 1 herein, in terms of the said clauses. So perhaps they are referring to clause 25 that I had read out. In terms of the said clauses of the agreement, the plaintiff, desirous of having some extra fittings and amenities in the Schedule 2 flat, submitted a modification letter dated 18/3/2013 in the format prepared by the defendant number 1, and the said modification letter was duly approved and accepted by the defendants on 20/3/2013. As per the modification letter, the plaintiff had proposed and the defendant had accepted that for the modification work stated therein, the defendant number 1 shall be entitled to the payment of labor expenses for doing the modification work, and the materials for carrying out the modification work will be supplied by the plaintiff at his own cost. It would not be out of place to plead that the plaintiff agreed to pay the differential amount so incurred by the defendant number 1 and 2 in carrying out the modification works, in as much as the defendant, as per the agreed terms, are liable to carry out the normal works. There had been no modification within the stipulated cost of 28,50,000 for the flat, including the material for such works. So their case, my lord, just pausing here for a moment, their case is that they wanted some alteration modification. So they proposed those modifications, that we want all these modifications. And then they said that insofar as labor is concerned, we will pay labor charges to you. Insofar as materials for carrying out these amenities and modifications are concerned, that we will supply on our own, and we will pay the differential amount from that total amount of 28,50,000. So this, according to them, was done by that letter, modification letter of 18/3/2013, and then they say they we agreed to it. Now, paragraph 10 onwards is how they've narrated how the dispute brewed between the buyer and the builder. If I may just quickly read 3 paragraphs. that as per clause 2 of the agreement, the plaintiff is liable to pay additional amount for AACV connection, including cost of substation meter. The defendant number 1 and 2 raised a demand upon the plaintiff for payment of 1,15,000 only against the electricity connection and other ancillary and incidental expenses for Schedule 2 flat. And the plaintiff on 12/12/2012 made the payment to the defendant in cash, and a money receipt in this regard was issued by the defendant number 1 to the plaintiff. That as per the agreed terms and conditions of the agreement, the plaintiff, in addition to the agreed consideration for purchase of the Schedule 2 flat, had also undertaken to make payment of taxes. Consequent to such understanding, the plaintiff, upon verbal demand of the defendant number 2, made a payment of rupees 60,000 against service tax and sales tax, and in acknowledgement to such payment, a money receipt dated 16/11/2012 was issued by the defendant number 1 in favor of the plaintiff. In spite of receiving the aforesaid amount, the defendant number 2, by letter dated 16/9/2013, raised a demand of rupees 72,465 only upon the plaintiff against service tax and VAT with regard to the sale of the Schedule 2 flat. As the defendant number 1 and 2 could not give any justification to the plaintiff regarding such service tax and VAT demanded from the plaintiff verbally requested them to give a written breakup against such demand, as the plaintiff is totally ignorant to the fact to that effect. The defendant number 2 insisted of the acceding to the request of the plaintiff, issued the letter dated 28/12/2013, and arbitrarily raised a demand of 90,000 only as current outstanding dues against the plaintiff, and also rupees 85,954 only against service tax and sales tax from the plaintiff. As the demand raised in the letter dated 28/12/2013 was unjustified and contrary to the earlier demand raised by letter dated so-and-so issued by the defendant number 2, the plaintiff by letter dated 4/1/2014 requested the defendant number 2 to justify and explain such hike in demand. By the same letter, the plaintiff also informed the defendant number 2 that in terms of the modification letter dated 18/3/2013, the defendant number 2 was not allowing the plaintiff to do necessary modification as per their undertaking, although all the necessary materials required for carrying out the modification works in the Schedule 2 flat have been supplied by the plaintiff at his own cost and expenses. By the same letter, the plaintiff requested the defendant number 2 to allow him to do the necessary modification works forthwith so as to enable him to take over possession of the Schedule 2 flat and to make payment of the balance amount to the defendant number 1 for purchase of the Schedule 2 flat. That in response to the letter dated 4/1/2014 of the plaintiff, the defendant number 2 issued a letter dated 23/1/2014, wherein the defendant, by referring to clause 25 of the agreement, arbitrarily and illegally demanded the plaintiff to make payment for the modification work without specifically stating what is the exact differential expenditure incurred by the defendant number 1 and 2 on labor for undertaking modification works, as the necessary materials for doing such works were already supplied by the plaintiff at his own expense. It is pertinent to mention herein that till date the defendant number 1 and 2 have not done any work towards completion of the kitchen and 2 toilets in the Schedule 2 flat. The plaintiff begs to state that for undertaking the modification works in the kitchen and the toilets, plaintiff has already spent huge amount of money in procuring the construction materials, and the same are now lying at the work site. In addition to this, the defendant number 1 and 2 have not connected the Schedule 2 flat with water supply and electricity. The defendant number 2, by his letter dated 23/1/2014, asked the plaintiff to deposit the demanded amount of taxes within a period of 15 days from the date of receipt of the said letter. 13. That the defendant number 2, in a most arbitrary, illegal and high-handed manner, issued a letter dated 9/4/2014, whereby the defendant unilaterally cancelled the agreement dated 24/4/2012 under the pretext that the plaintiff did not pay money demanded by the defendant. In this regard, it is stated that while issuing the letter dated 9/4/2014, the defendant number 2 had deliberately ignored the fact that till date the defendant had paid a sum of rupees 25 lakhs to the defendant as a part of the consideration for purchasing the Schedule 2 flat, and have made additional payment of 1,15,000 to the same defendant against installation of electricity supplied to the Schedule 2 flat, and rupees 60,000 towards service tax and VAT. the defendant number 2 has also deliberately overlooked that till the date of construction of the Schedule 2 flat, more particularly construction of the kitchen and bathroom, have not been completed by the defendants, and in such a situation is not legally justified on their part to make any demand for final payment of the consideration money. So we cancel, the allegation is we arbitrarily cancel the agreement. Will probably rise. Okay, I'll continue.
We'll resume at 2 o'clock.
Yes.
I'm from Gauhati, from Mumbai.
Okay.
So date may be in the meantime, I'll file my work.
In the meantime. So you have the instruction to appear on their behalf.
Not definite, but they said that they will come and.
No,
Because
the
he
thing
can-
is that notice has been served upon them. If
Yes,
they refuse or they fail to appear, then we will proceed ex parte against them.
That's what they said that they will come, but he has not received the notice.
No. We have checked it in the website.
Delivery report has been there.
Yes,
So
notice has been delivered.
the date may be in the meantime, they will come and I will appear if they appoint me.
When?
After 2 weeks, 2-3 weeks.
No, after 2 weeks means you say a definite date because he is from Delhi.
He's coming on 17th of June. Another matter is fixed.
17th of June.
June, there are multiple litigations regarding the same property.
Okay.
So the same date may be fixed.
June 17th.
17th of June.
Okay.
Because he is a senior citizen, one chance. If
Yes,
my
yes.
learned friend is
Okay.
requesting, may be granted to him because he is a senior citizen.
Heard Mr. Sorma, learned counsel for the appellant. Then Mr. Cabra, appearing on behalf of the legal heirs of the respondent. Mr. Cabra on instruction submits that the legal heirs of the respondent will come down to Gauhati and in the meantime he will file the wakalatnama and a price for listing the matter after 2 weeks. Parallel races shall list the matter on 17th of June.
17th of June.
17th of June.
At least my application will be decided on that date after filing the wakalatnama for
Okay.
impleading because
Okay.
as per my knowledge, only 2 legal heirs are.
Okay, on
left.
that day an endeavor will be made to finally hear and dispose of the petition, dispose of the appeal, provided he file his wakalatnama.
If he is not filing wakalatnama on 17th of June, then ex parte may be
Okay.
highly okay.
Yes.
May please establish. So, my lord, I had taken your lordship through the plaint. My lord. So the categoric stand, the 3 things which I'd like to just recapitulate. Paragraph 9 of the plaint, the plaintiff says that on 18/3/2013, he floated a proposal that insofar as the remaining work and modifications are concerned, I will pay only labor charges, materials I will supply on my own, and the builder had agreed to it. That's his categorical statement in paragraph 9, 18/3/2013. He says that there was an understanding to that effect. Then insofar as modification and finishing works are concerned, he will supply the materials on his own and only pay labor charges. And he says that I accepted that. Paragraph 11 and 12, his allegation is that I kept on asking him money on account of electricity, on account of tax, VAT, service tax, etc. And when he said that clarify what that exact amount is, give me a breakup of the amount, I did not give him the breakup of the amount. Therefore, he did not pay. And eventually on 9/4/2014, I issued a termination of the agreement. So these are his moot allegations. And besides that, he says that out of 28 lakhs, he's already paid 25 lakhs. Now, accordingly, the prayer, if your lordship has page 32, my lord, there's a host of prayers that he claims, my lord. Firstly, prayer number 1 is a declaration that the agreement is valid and binding on defendant 1 and 2, and that letter of 9/4/2014 by which I had cancelled is illegal and bad. Then there is a decree directing the defendant 1 and 2 to complete construction work of the Schedule 2 and thereafter hand over possession of the same to the plaintiff. Then there is a decree for permanent injunction not to transfer it to any third party. Then there is a decree that the defendant 1 and 2 have defaulted and therefore are liable to pay 14,000 per month with effect from 24/10/2013. Then additional compensation at 14,000 per month, etc., etc. I just missed one point, Manoj, that they also say that after the cancellation of the agreement, they had already accumulated the building materials to do the finishing work, and I did not let them bring those materials to site. That was another of the allegations. Now, if your lordship has the written statement, written statement starts at page 45, but I'll just read 3 paragraphs starting from page 47 to indicate the moot defense of the defendant number 1 and 2.
Paragraph number?
Paragraph 12, page 47 it begins. May I read, Manoj? That the statement made in paragraph 9 of the plaint are not wholly correct. It is specifically denied that as this modification letter the plaintiff had proposed and the defendant accepted that for the modification work stated therein, the defendant number 1 shall be entitled to the payment of laborers' expenses for doing the modification work, and the materials for carrying out the modification work will be supplied by the plaintiff at his own cost. It is stated that as per clause 25 of the agreement dated 24/4/2012, it is specifically provided that extra payment must be incurred by the purchaser second party against the extra additional modification work subject to the prior consent of the first party and will be executed by the first party only. And regarding the same, the purchaser second party cannot raise any objection. Therefore, the plaintiff, being the purchaser, is liable for the payment of any additional work done by the answering defendants as per his request. Then paragraph 13, that with regard to the statements made in paragraph 10 of the plaint, it is stated that in terms of the agreement dated 24/4/2012, the plaintiff has deposited an amount of 1,15,000 towards installation of electricity connection, etc., as per provision of law, and the plaintiff, being the purchaser, is liable for the payment of VAT, service tax, etc. That the statements made in 11 and 12 of the plaint are not wholly correct. It is stated that as per prescribed rate of the authority, and the same is calculated and required to be paid against every installment paid by the plaintiff in terms of the agreement dated 24/4/2012. Well, he's referring to tax, service tax. Accordingly, the plaintiff had made payment of 60,000 being a part of the service tax and sales tax. However, as the plaintiff also received to pay VAT and service tax for his subsequent payment of installment, the answering defendants by their letter dated 16/9/2013 had informed the plaintiff regarding his due amount of 72,465 against service tax and VAT, with a request to pay the said amount within 7 days from the date of issue of the said letter. However, in spite of the receipt of the said letter, the plaintiff failed and neglected to pay the aforesaid amount for VAT and service tax, as in spite of it, the plaintiff failed to pay his due share amount for VAT and service tax within the time with penalty. The said amount increased to 85,038. And therefore, the answering defendants, by their subsequent letter dated 28/3/2013, again made request to the plaintiff to make payment of the aforesaid amount of 85,038 with included penalty against non-payment of sales tax and service tax. But in spite of it, till cancellation of the agreement, the plaintiff has refused to pay his due taxes to the concerned authority. It is stated that in terms of clause 25 of the agreement, the additional work will be executed by the first party only, and therefore the question of not allowing the plaintiff to do any modification by himself does not arise. Moreover, the answering defendants by their letter dated so and so requested the plaintiff to make payment of the modification work, if any, along with scheduled payment, which amount was already intimated by the plaintiff by earlier letters dated 4/9/2013 and again on 28/12/2013. But in spite of it, till cancellation of the agreement, the plaintiff failed to pay his due amount in terms of the agreement. It is specifically denied that the plaintiff has spent any amount of money for undertaking the modification work in the kitchen and toilet of the flat as alleged by him. Now, my lord can skip over to page 49, my lord. Paragraph 16. That the statements made in paragraph 14 of the plaint are not wholly correct. It is specifically denied that the answering defendant is undertaking any secret negotiation with any third party for sale of Schedule 2 flat. It is specifically denied the termination of the agreement is illegal merely on account that the plaintiff had paid a portion of the agreed amount. It is stated that in terms of the agreement, it was agreed between the parties that the plaintiff being the purchaser is liable to pay the agreed sale amount in installment, and it is also provided in the said agreement that in clause 7 that the second party shall further specifically agrees that in case he cannot make the payment as per schedule above, the agreement becomes void. The first party shall have the right to book the residential unit on as is various basis with another purchaser without any objection whatever from the second party. 10% of the booking amount or 20,000, whichever is higher amount, will be deducted as administrative cancellation charges, and the same will be refunded without any interest to the second party only after the agreement with the new owner. Therefore, cancellation of the agreement dated 24/4/2012 is made on the basis of and in compliance to the term of the agreement itself, which cannot be termed as illegal. It is stated that admittedly the plaintiff paid 25 lakhs so and so against agreed amount of 28,50,000. So there is a balance of 3,48,000 is due. Apart from that amount, till cancellation of the agreement, the plaintiff was liable to pay 77,2083 as sales tax, rupees so and so as penalty against non-payment of tax, and another amount of rupees so and so towards modification of the flat as per his specification. On the date of cancellation of the agreement, there is amount of rupees 4,55,865 is due from the plaintiff. So, my lord, the moot defense is that first of all, that arrangement that they said happened on 8/3/2013, that they will do that additional work, that was denied, that there was no arrangement as such, because whatever modifications or finishing work is required to be done inside the flat, that as a builder, I will only do, and you will pay the additional charges if any, but you cannot come and complete the works. And secondly, therefore, the question of allowing you to bring forth materials into the site to complete the construction is not permissible under clause 25. Then additionally, the other defense is that there were other dues which were part of the agreement. So as for example, electricity, sales tax, VAT, etc. We issued repeated demands. Since you did not come forward for payment, we have cancelled the agreement. There is absolutely nothing wrong with the cancellation. That is the stand of the defendant, my lord. Now, my lord, will have the judgment, my lord. Judgment starts at page 74, my lord. Just one thing I will quickly point out, my lord. During the course of our argument, the defendant number 1 had moved an application to frame an additional issue regarding readiness and willingness, my lord. That application was rejected with the order at page 67. It's an order dated 7/10/21. 67, my lord. That's the order rejecting framing an additional issue on readiness and willingness, my lord. Against that rejection, we had come to the High Court, my lord. We, as in the earlier counsel, my lord. At page 70, your lordship finds the High Court order. 12/11/21, my lord. Now, my lord, this is what the my lord, if I may straight away take your lordship to the operative portion at page 73, my lord. reverting to the case at hand, I have decided not to agree with the petitioner. The reason is that court is of the opinion that the learned trial court has correctly passed the order. If the petitioners are aggrieved by the decision which the learned trial court might express in future, the petitioner will have the right to file an opportunity, will have the opportunity to file an appeal, where the petitioners would have the opportunity to place the grievance. The court is of the opinion that under the given circumstances, the power of the High Court under 227 of the Constitution cannot be exercised. So therefore, that issue was not specifically framed, but I must admit that that was taken note of during while writing the judgment. So page 79 of the judgment is where your lordship finds the issues. Issues as your lordship found. Page 79. So perhaps 2, 3, and 4 are the relevant issues, my lord. And they have been discussed at page 81, the last part, 2 and 3. '82 onwards, your lordship may have the judgment, para 14. That is where the issues have been discussed and decided. Para 14, my lord. From the pleadings of the parties, it reveals that there is no dispute regarding execution of the agreement dated 24/4/2012 and subsequent payment of rupees 25 lakhs 290 out of the total cost of 28 lakh 50,000. Then payment of rupees 1 lakh 15,000 towards electricity connection and rupees 60,000 towards service tax and VAT by the plaintiff to the defendant number 1 and 2 for the scheduled flat. Dispute arose when the plaintiff sought justification and breakup of the further demand of rupees 72,465 made by the defendant number 2. According to PW1, without giving justification, defendant number 2 wide letter dated 28/12/2013 raised demand of rupees 90,000 as current outstanding dues and rupees 85,954 against service tax and sales tax. Subsequently, wide letter dated 23/1/2014, defendant demanded to make further payment for the modification work without specifically stating the exact exact differential expenditure. Therefore, finally, on 9/4/2014, defendant unilaterally cancelled the registered agreement on the pretext that the defendant had failed to make payment of the demanded money. The letters are exhibited as Exhibit 15 and 16. The letter issued informing the cancellation of the agreement is exhibited as Exhibit 19. These documents remain unrebutted. As per DW, in terms of clause 25 of the agreement, plaintiff is liable for the payment of all other additional works. But in spite of stipulations, plaintiff had failed to make payment in violation of the agreement. That in such a way, till the date of cancellation of the agreement, there is due of rupees 4,55,865 from the plaintiff. So and so for total consideration, so and so as against tax, so and so as against penalty, and another amount of so and so towards modification of the flat as per specification. Para 16. During cross-examination, DW1 has stated that while letter dated 6/9/2013, the Exhibit A, he had raised a demand of 72,465 against service tax and VAT without giving any written breakup to the plaintiff about the details of the compensation and service tax and VAT. That further, he has not submitted any calculation on the basis of which he demanded so and so from the plaintiff, that he had not raised any statement of account to support the amount demanded from the plaintiff against VAT and service tax, that he does not know on what basis of breakup taxation is calculated, as the same has been done by his CA firm, that he cannot say whether penalty relates to service tax or VAT, that he had not submitted any proof to show that the defendant number 1 is registered under service tax and VAT. Further, till date, he had not deposited the money demanded by him against tax and penalty to the income tax department, that he had not served any notice upon the plaintiff alleging that the plaintiff has continued the breach of the clause of the agreement. DW2 Damodar Borua has stated that the possession of the flat has not been handed over to the plaintiff till date, that if the plaintiff was able to give his flat on rent after taking over possession of the same in the year 2014, then he could have let out the same on rent at the rate of rupees 15,000 per month. Further, he has stated that the plaintiff is living in Gauhati and with his family till date in rented premises, since he does not have any accommodation at Gauhati. Thus, from the cross-examination of defendant number 2, it is seen that he had raised demands without justifying his claim. Further, it reveals that in spite of requests made by the plaintiff, he had not produced a breakup of his claim. Moreover, surprisingly, he is not even aware whether his firm is registered under VAT service tax or not. The above contention made by the defendant indicate that he had tried to take undue advantage of clause 25 of the agreement, which reads as the extra payment must be incurred by the purchaser against extra additional modification work, subject to prior consent of the first party, and will be executed by first party only. And regarding the same, the purchaser can't raise any objection. From the evidence of the plaintiff and DWs, it reveals that the plaintiff has made payment in terms of the agreement in Exhibit 1. It is obvious that the agreement reserves right of the defendant seller to cancel it if the plaintiff fails to make payment as per schedule of payment, but that does not necessarily mean that seller on the garb of the stipulation provided in the agreement can demand arbitrarily without providing any sort of justification. Situated thus, the act of defendant number 2 of raising demand without justification and explanation, and thereafter unilateral cancellation of the agreement in spite of the fact of payment of substantial amount of consideration amount, electrical connection charge, and VAT and sales tax is found to be arbitrary, whimsical, and unjust. In view of this above, this court has no hesitation to hold that the registered deed of agreement dated so and so is valid and binding upon the defendant number 1 and 2. So far as the entitlement of the plaintiff for specific performance of agreement is concerned, it is seen that he was very much ready and willing to perform his part of the agreement by paying substantial part of the consideration amount, electrical connectivity cost, and demanded service tax and sales tax. As appeared from the evidence of DW2, plaintiff had supplied all sorts of materials for the modification work in terms of their mutual understanding. Wide modification letter 23 2013, the exhibit 12, but it is the defendant who had not allowed the plaintiff to carry on the works. It also reveals from clause 5 of the agreement that the construction of the scheduled flat is to be completed within 8 months from the date of the agreement, provided the prospective owners pay their respective due, the first party as per schedule. There's also stipulation that in case of unfortunate circumstances, acts like natural flood, acts of nature like flood, fire, etc., civil or military unrest, quarantine, shortage of men and materials, force majeure clauses, the date of completion may be extended. From the evidence of DW2, it reveals that although construction of the flat in question is almost completed by the defendant number 1 and 2 in the year 2014, but is yet to be connected with water supply and electricity connection. On the point of readiness and willingness of the parties to perform their part, learned counsel of the plaintiff has relied upon the following decisions. I'll skip that, Malone. Then para 24, in the light of the aforesaid decisions of the Honorable Supreme Court, it is seen that act of the plaintiff in respect of payment, supply of materials to the construction site for modification of the flat are sufficient to show his readiness and willingness to comply his part of the contract. In view of the above, I am of the considered opinion the defendant number 1 and 2 are liable to execute registered sale deed to plaintiff in respect of Schedule 2 in pursuance to deed of agreement dated 24/4/2012. Now, if your lordship may skip over to page 87. In the result, the order at para 29, Lord. In the result, the suit of the plaintiff is decreed on contest without cause. It is hereby decreed that plaintiff is entitled to get specific performance of agreement dated 24/4/2012, subject to payment of outstanding balance consideration amount within 1 month from the date of the decree. Further, the defendant number 1 and 2 shall execute the sale deed in favor of the plaintiff within 1 month from the date of receipt of the consideration amount. Plaintiff is entitled to get the construction of the flat completed by defendant 1 and 2 prior to execution of the sale deed. Plaintiff is entitled to get compensation from the defendant number 1 and 2 at the rate of rupees 10,000 per month from 9/4/2014, the date of cancellation of the agreement, till handing over of the possession of the flat to the plaintiff. It is made clear that if the defendant 1 and 2 refuse to comply the said order and decree of this court, the court will execute the sale deed in favor of the plaintiff by exercising the provisions under Order 21, Rule 34. So this is the judgment.
What are the grounds in appeal?
Lord, grounds are mostly on the issue of readiness and willingness, my lord. Of course, the memo was drafted by the erstwhile council, my lord. I'll also stick to that only, readiness and willingness, my lord. Why I say so, my lord, insofar as the other part is concerned, my lord, I must concede, my lord, there could have been better materials to substantiate that these were the dues insofar as service and
No, that's all right. That petition was rejected.
I'm not on the petition, my lord. I'm not on the petition, my lord. Generally on the ground of readiness and willingness, and whether they are whether there is a personal bar to the relief of specific performance in terms of section 16. Now, insofar as the part concerning non-payment of service tax and VAT is concerned, my lord, that I bow down, my lord, the trial court perhaps is right that we could have brought in better materials to show that this was the exact due, these are the demands, and the plaintiff having failed to pay the amount, he acted in breach of the contract himself and was hence not entitled to specific performance. That ground perhaps I must not unnecessarily urge because the documents do not support me. What I'm on is, my lord, the arrangement that they say happened in the year 2013. 18/3/2013. Now, this is the arrangement on the basis of which the trial court has said that from the fact that the plaintiff had brought materials to complete the finishing works and the modification works, we can assume readiness and willingness. And from there itself, the plaintiff is entitled to a decree for specific performance. Now, if your lordship comes to that particular document, my lord, I have flag marked it, which is Exhibit 12. It's in that C file, my lord, should find a green flag, fresh green flag. Because my categoric stand throughout was there was no such arrangement. Clause 25, I have to do it. I'll take your lordship again to clause 25 and 17. But before that, if your lordship has Exhibit 12, my lord.
Yes.
Now, this is dated 18/3/2013, which according to me is a very vital document, and the judgment is perverse for having not considered in its true perspective. Now, this is addressed by Sashi Mohan Das, and its subject is modification letter. It says, it is addressed to me, my lord. With the above mentioned reference, we would like to modify our flat as mentioned below. Then he says, the modifications are indicated, my lord. Number 1, remaining inside color. Number 2, all sanitary fittings and bathroom fittings, including stabs, basins, with all wall tiles. Now, I will show from the schedule 2 that this is not a modification. It is in fact a finishing work, because without wall tiles and bathroom fittings, a flat itself will not be complete. Then 3, kitchen tiles, wall, marble slabs, wash basin and water tap. 4, sliding doors in the second bedroom with aluminium and glass wall. Main door, all doors, locks, handles, hooks. So he says these are modification. However, from the reading, it appears that these are finishing works. Now, your lordship will mark the note. Note. Has your lordship found it? Note. The above modifications will be done by me. And please deduct your estimated cost, including labor cost, for the above modifications from my present outstanding dues. Now, what he's trying to say is that you stop your construction works. I will do rest of. I will fit my own door, my own basin, my own tiles in the bathroom and in the kitchen, and then you will deduct that cost from the outstanding due that is payable from my end. Now, when he says this, my lord, he says it has been accepted. It has been accepted, which I have denied in my written statement. And he shows the signature of one G. Goswami on 23/2013. And he says that this is an agreement as if it's a novation, because it cannot be an understanding, because it has to be a novation, because it is superseding clause 17 and 25. For a moment, if I may take your lordship again to those two clauses, my lord. Because ultimately, this letter, which is their own document, goes to show that what they are essentially trying to do is act at variance with the same contract, which is a requirement under section 16. Now, if your lordship has page 42 for a moment. Clause 17, my lord.
Yes.
Clause 17, that the purchaser second party shall not be entitled to make any act, deed or thing in respect of the residential unit, it being clearly understood that all acts, deeds and things in respect of the residential unit shall be done only by the first party builder until it is handed over to the purchaser. Then clause 25, which is if again on the following page. That extra payment must be incurred by the purchaser second party against the extra additional work subject to the prior consent of the first party. It requires a consent from my end and will be executed by the first party. Your lordship will mark the word only. And regarding the same, the purchaser second part cannot raise any objection. So what is the intention of the parties? I will do all the construction till it's finished, and after that I will hand it over to you. Second is, even if you want modifications, I will only do it and you will just pay me the enhanced amount. Now, when they issue this letter of 2013, my lord, they are trying to bypass these two clauses and saying that we will not pay you money anymore. Whatever the balance outstanding dues are, we will not pay money because we are taking over the project and we will do bathroom fittings starting from doors, wall tiles, etc. And therefore, whatever outstanding dues are there, you adjust it with that. Now, the moment this has a crucial bearing, because I know, my lord, other points I may not be very successful in persuading your lordship, but what it has a very relevant bearing because of section 16 of the Specific Relief Act as it stood then prior to amendment. Because they are personal bars. Now, the moment he issues that letter of 2013, what he is essentially suggesting is that I will not pay you the balance amount. I will do the remaining works on my own, which is otherwise not permissible under 17 and 25. So if that be so, my lord, two things can be gathered from this proposition that he floats. Number one, that he is not willing to pay the outstanding dues because he wants it adjusted, my lord. And number one, and number two, my lord, he wants to act at variance of the contract, more specifically at variance with 17 and 25, both of which personally bars him. Let us for a moment accept their case that I acted in breach, I demanded more money than that was due, my lord. But the moment they come for specific performance, they have to satisfy that there are no personal bars to that relief under section 16, my lord. So, my lord, section 16 basically B says, C says that who fails to aver and prove, 16C. 16B, first of all. 16B has perhaps remained unchanged, my lord. Who has become incapable, specific performance of a contract cannot be enforced in favor of a person. B, who has become incapable of performing or violates any essential term of the contract on his part remains to be performed, or acts in fraud of the contract or willfully acts at variance with or in subversion of the relation intended to be established by the contract. And C, my lord, perhaps the book which your lordship has says who fails to prove, my lord, the earlier unamended says who fails to ever and prove that he has performed or has always been ready and willing to perform the essential terms of the contract which are to be performed by him other than the terms of the performance of which has been prevented or waived by the defendant. So both the personal bar kick in because of their own admitted document, which is Exhibit 12, which in my respectful submission was not construed in the correct light. Because because he accepts variance with 17 and 25, and C, because his intention is very clear. He clearly says that you please adjust the amount with the outstanding dues. Now, how the trial court?
Can it be interpreted that he is not willing to pay the balance amount?
Precisely my point, Manoj. Because he says, Manoj, in that note he says,
Hmm.
No,
As you have submitted, that letter was accepted by you.
that I'm coming to that now.
Hmm.
Now, what he does is, my lord, he says that this was the arrangement. I will now take over the project. Whatever things you've done is done. Rest I will do, and I will not whatever outstanding dues are due. You adjust it with this because since I'm taking over. That's and this document was never interpreted by the trial court. Strangely, my lord. It in fact. But I'll take your lordship to that part of the what does this note basically essentially imply? The above modifications will be done by me. When he's not supposed to make any modification, all modifications I'll do. Malab. Please deduct
whether this relates to any modification of the project that has been mentioned in the agreement.
Yes, my lord. My lord can construe it in two ways. Either your lordship can hold that these are finishing work. That also he cannot do because of clause 17. And if they are construed to be modification or extra work.
You see, the installation of sliding door.
Yes, my lord.
Would it amount to any modification?
If not modification, it would amount to completion of the flat because the sanitary fittings are not there. For clarity, my lord. If your lordship has page 43, my lord. Page 43 of the memo, my lord.
Yes.
Now, Schedule B. So, this is the description of the residential flat. I am supposed to deliver it with all the description, matching the description as Schedule B. Now, Schedule B says floors, vitrified tiles, toilets, also floor tiles, etc., branded sanitary fittings, concealed plumbing, sanitary system, kitchen also standard quality, kitchen slab, ceramic tiles on wall so and so. 4 is doors and windows. Main entrance door is wooden doors. All other doors are flush doors with single lock with wooden frame. Windows will be of double-sided aluminium wall, etc. So I, as a builder, as per the agreement, I am supposed to finish the flat in tune with Schedule B, and until I finish this flat by doing in the manner described in Schedule B and deliver it to you, you cannot step in and do any sort of a work. And beyond this, even if you want modifications, then also under clause 25, I will only do it and you will merely pay me the expenditure. Now, the note says that basically the indication of the note, if I've understood this correctly, these are the works. Please halt your constructions. I will do it on my own. And after
no, that kind of interpretation.
My lord, I'll just read the exact note again. First of all, at Exhibit 12, my lord, he says remaining inside color, which is part of Schedule B, the number 6, my lord, serial number 6.
No. If he chooses a particular color, then
Right.
what wrong with him?
No. Let us assume, my lord, let us assume one. Let us go since it has fallen for him. Lordship, let's say he's merely choosing a color. Fine. Number 2, all sanitary fittings and bathroom fittings.
Yes. Ordinarily, what the builders used to do,
My lord.
the fittings are always always available in the market.
Right. No, that is
Not
fine.
of the branded, branded articles.
That is absolutely fine, my lord. Let us suppose he's just making a choice. Let us suppose he's making a choice. No difficulty with that. The problem is he's saying that all these works, note, my lord, the above modifications, call them modification, finishing works, whatever, works. The above modifications will be done by me, he says. Please deduct your estimated cost. including labor costs
Mm.
for the above modification, from where do you deduct it? From the present outstanding dues.
Mm. Mm.
Now, how does the trial court interpret it, my lord? Now, before I come to that, my lord, he says that I accepted, which I denied in my written statement. I've taken your lordship to the pleadings. I said that the question doesn't arise because under clause 25 and 17, I am supposed to do the works. How can you step in? I'm sorry. And then I say, my lord, therefore you cannot bring materials to the site. And if you want any modifications, I'll do it. You pay me the extra money. He says, no, I took the materials on site. I wanted to carry on, but I did not permit him, my lord. So first thing first, my lord, the trial court ought to have decided that whether this particular arrangement was agreed upon and there was a change or a novation to clause 17 and 25, my lord. Now, if your lordship has the evidence, my lord, the acceptance I denied, my lord, and in the evidence in affidavit, my lord, the original of this document is not produced, my lord. And the signature, who is that particular gentleman? He says he accepted. That signature is also not even marked. My lord, this was part of Exhibit 12, my lord. It says proved with office copy, and my lord will see the signature because he says someone endorsed it on 23/2013. Who is that particular gentleman called G. Goswami? I'm not sure. That's what I read from that document. Who is G. Goswami? Whether he was an office bearer of the defendant number 1 company, whether his receiving would imply that I have accepted this particular absurd term that the buyer himself comes in and completes the flat. There is nothing, absolutely nothing to prove that that document, that signing of that document by one particular gentleman when the signature is not even exhibited, that it amounted to a novation of clause 17 and 25, and 17 and 25 were superseded, my lord. And beyond that, my lord, what is my lord will again come to page 22, my lord. I'm sorry, page 85, para 22, my lord. First of all, the trial court should have seen, in my respectful understanding, my lord, should have seen whether 17 and 25 were superseded. Now, it could have been superseded by if the plaintiff would have proved that letter of Exhibit 12 and said that I also accepted, they also proposed that they will do the remaining works, and instead of that, instead of paying the outstanding dues, we will adjust it. Now, page 85, paragraph 22, my lord. Somewhere in the middle, just after the word service tax and sales tax, as appeared from the evidence of DW2. DW2, I must clarify, is the landowner. Plaintiff had supplied all sorts of material for the modification works in terms of their mutual understanding. Where did the trial court come to a finding? How did the trial court come to a finding that there has been a mutual understanding? Why modification letter dated 23/3/2013, the Exhibit 12, but it is the defendant who had not allowed the plaintiff to carry on the works. Admittedly, my lord, I did not allow him. It also reveals from clause 5 of the agreement that the construction of the schedule, that we are not concerned. And then on the following page, my lord, at paragraph 24, it says, in the light of the aforesaid, para 24, my lord, in the light of the aforesaid decision of the Honorable Supreme Court, it is seen that act of the plaintiff in respect of payments, supply of materials to the construction site for modification of the flat, etc., are sufficient to show his readiness and willingness to comply his part of the contract. I will argue the contrary, my lord. The fact that he had taken materials on his own to the site is suggestive that he's acted at variance with the contract, because he's not supposed to do it at all. And the fact that he sought an adjustment of the outstanding dues on that count is suggestive of the fact that he's not even willing to perform the contract, or maybe he's not ready with the amount, which is why he says stop all works I will adjust all outstanding dues that I have to pay. I will do the rest, my lord. So this itself shows number one, unwillingness and his action of acting in variance, my lord. My lord, I can understand, my lord, that the trial, what weighed on the mind of the trial court may perhaps.
No. Trial court only considered the readiness and willingness.
Yes, my lord.
It is not considered whether any terms and conditions
Yes,
of the
exactly.
agreement is violated or not.
Or has it been actually modified by way of what the trial court calls a mutual understanding?
Hmm.
Where is that mutual understanding, my lord? I did not sign it. Who Goswami is, they did not prove it, my lord. It was a clear case of denial that no such arrangement has taken place. On top of that, there are clear terms to the contrary in the form of clause 17 and 25. And how did then the trial court come to a finding that there has been a mutual understanding, number one? And number two, my lord, on the other hand, the document was used against me to say that, look, he is getting materials on his own, etc. This shows his readiness and willingness, my lord.
Yes, Mr. Rahul,
My lord.
who accepted this exhibit 2?
My
Oh, no, sorry, exhibit 12.
12, my lord.
Yes.
I'm coming, my lord. Have you concluded, my
No,
lord?
not completed.
Huh?
Not completed.
Completed. My lord, only I'm really grateful to my for my learned friend, my lord. He has very candidly admitted the basic fact, my lord, that if you peruses the termination letter, these are all afterthought, my lord. The modification letter contains this should have contained there is a amendment of the agreement. These are all afterthought. The core issue, my lord, what has happened actually.
No. Mr. Rahul, Mr. Dekka has not completed his argument. Just I am asking you, so who has accepted this letter? Exhibit 12.
Exhibit 12, we have
Yes.
exhibited.
Huh?
We have exhibited.
No, you have exhibited. Who has accepted this document?
They have not denied about this letter in the written statement.
Okay.
If you look at peruses paragraph 9 of my plaint, my lord, lordship will come to paragraph 9 of my plaint. First of all, may I just lordship indicate the readiness and willingness, my lord, with my limited understanding.
No, Mr. Rahul, you will argue that you will argue on that point.
Lordship.
But first, answer my query.
It is absolutely there, my lord. There cannot be any case for specific performance without readiness and willingness.
No, that's all right. That's all right.
If your lordship comes to page 21 of the memo of appeal.
Yes, paragraph number 9.
9, my
Yes.
lord.
Yes.
That the agreement dated 24/4/2012 stipulates that the condition that the residential units in Greenhaven shall consist of amenities described in Schedule B in the agreement along with some option for modification of amenities. The clause 25 of the said agreement also lays down that the extra payment will be incurred by the purchaser, that is the plaintiff herein, against the extra additional modification work subject to prior consent of the first party, that is the defendant number 1 herein. In terms of the said clause of the agreement, the plaintiff being desirous of having some extra fitting and amenities in Schedule 2 flat submitted a modification letter dated 18/3/2013 in the format prepared by the defendant number 1. If your lordship peruses this letter, this cannot, how can this letter, if your lordship again goes to this exhibit, my lord, this is not a handwritten letter of a purchaser. These are formats kept in their own office, my lord. This is taking of 180-degree turn is very undesirable, my lord. It is just the seal of their builder, my lord.
No, that's all right.
It is their own seal, my lord.
No,
Merely
because you have written a letter to them
we have not written
in a letterhead provided by them.
in their presence. In their presence, in their office. Where is there evidence to disprove this? My lord, I'm reading it out, my lord. I'm reading it out. The same modification letter was duly approved and accepted by the defendants on 23/2013. Clear readings on record. As per the same modification letter, plaintiff had proposed and the defendant number 1 had accepted that for the modification works, no amendment of the agreement, my lord, as argued, my lord. As per the modification works,
Mm,
There is an acceptance for the modification works.
mm,
As rightly indicated by your lordship, certain amenities have always remained, if you have normally seen,
mm,
remain substandard, my lord.
mm,
Every purchaser, my client is a professional, my lord.
Mm.
He is desirous of having some good amenities in his bathroom. Is it so wrong, my lord? To approach the builder and say, see, and when the agreement itself has the clause, my lord,
mm,
and he is ready to pay. In fact, what has happened, my lord, he has purchased the articles on his own. He said the interpretation given by here, my lord, is totally wrong. He said, I have purchased the articles of my own, kindly install these items, and whatever labor, in my understanding, whatever labor in expenditure that will be incurred, okay, you adjust it.
mm.
Is it, can it at all be interpreted in such a way that he has taken over the project? Well, what type of argument? Well, this will bring catastrophe, my lord.
Mm.
A format, and they have kept this format because they are.
Okay, how in the written statement,
I'm
they have dealt with this?
Accepted that for modification of the work stated that the defendant shall be entitled to the payment of labor expenses
Mm,
for doing the modification work, and the materials for carrying out the modification work will be supplied by the plaintiff at his own cost.
mm,
It would not be out of place to plead that the plaintiff agreed to pay the differential price so incurred by the defendant number one and two in carrying out the modification work, in as much as the defendant, as per the agreed terms, are liable to carry out the normal works had there been no modification within the stipulated cost of so and so for the claim included in the including the materials as such work. My lord, the fact remains, even the judgment shows, even had they completed the kitchen, this argument would have lied, my lord. This argument would have hold good, my lord, had they completed the kitchen in any case. It has still remained like that.
mm.
The written statement, my lord, the judgment, the evidence, it will show that neither the kitchen nor the bathroom, no, they did not do the installation work.
Mm.
Rather, they are trying to project a picture that I am forcefully trying to go in. There is nowhere, my lord.
Okay,
How-
now you come to the written statement.
Statement, my lord, you will see the written statement, my lord, paragraph 12, my lord. My lord, in the same memo of appeal, my lord.
Page number.
Come to paragraph 12, my lord, page 47.
Yes.
That the statement made in paragraph 9 of the plain are not wholly correct. It is specifically denied that the statement that as the said modification letter, the plaintiff had proposed and the defendant number one accepted that for the modification work stated therein, the defendant number one shall be entitled to payment of labor expenses for doing the modification work, and the materials for carrying out the modification work will be supplied by the plaintiff at his own cost. It is stated that as per clause 25 agreement, so it is specifically provided that, my lord, will see, it is specifically denied that the statements that as the said modification letter,
Mm.
once you said it's the said modification letter, you are literally admitting to the fact about the existence of the letter. You are nowhere you have pleaded that this has come out of the blue, this is my manufactured document. I will lead evidence when you have denied it in your written statement, in your pleadings.
Mm.
My burden comes then, my lord.
Mm.
They have nowhere denied about the existence of the document.
Mm.
They are denying the contents or trying to give another color to the contents of the document.
Mm.
That means the existence of the document is admitted.
Mm.
You cannot blow hot and cold like this.
No, that's all right. Now you come to this page number 85. Para number 22, wherein the trial court has observed that as appeared from the evidence of DW2, plaintiff had supplied all sort of materials for the modification work in terms of their mutual understanding. So
Why
this
modification
mutual-
letter 23 2013? Yes, my lord.
No, this mutual understanding. Where from which pleading this words born out?
My lord.
From which pleading?
Lordship.
This is this finding born out.
That mutual understanding.
Yes.
From my plain, my lord. From
Mm.
my plain.
When I say that in their own format, I have written these things. In their own prepared format, they have accepted. Why, again, I will come back to the pleadings of my plate, my lord. Paragraph 12, my lord. Paragraph 9, I apologize, my lord.
No, no. That is your averment.
Yes, lordship.
But
Where
in
is the
their
mistake? Did I-
in their written statement, though they have not.
In the written statement, again, if your lordship comes to paragraph page 47, paragraph 12,
Mm,
may I just read out again this paragraph, my lord,
Mm.
which is in against the paragraph 9 of the plate, my lord.
mm,
That the statement made in paragraph 9 of the plate are not wholly correct. That means they are admitting the part.
mm,
It is not denied in toto, my lord.
mm,
What they are trying to say is, actually, my lord, what has happened?
mm,
They wanted to install. There are many things which have happened.
mm,
Once the purchaser said that I need this articles, builder said, okay, I will install those. And it is a normal process that they will exaggerate the billing, my lord.
mm,
They will exaggerate the billing. What my client did is said that no, I will purchase it. I will give it to you. You take the labor costing.
mm,
This is exactly what has happened, my lord.
mm,
My client, the plaintiff, instead he tried to guard himself from paying extra money to which is not required
mm,
to the builder, my lord. Builder was trying to impose pressure upon him to extract more money because they said that no, we'll purchase everything, we'll furnish everything. Okay, had it been as per the like that, the modification would not have come. Modification would not have come. The question of modification would not have come if they would have installed everything according to the wish and desire of the purchaser, my lord, which was not done. And there is a clause also. There is a clause in the agreement.
mm,
In furtherance of that clause, and that clause does not, there is no particular stipulation in the agreement, my lord,
mm,
which prohibits, my lord. There has to be a prohibitory clause, my lord. There is no clause in the agreement which prohibits the purchaser from purchasing the material and giving it to the builder for installation.
mm,
The argument which they are trying to say that he purchased it on his own, this is not, this is violation of the contractual terms and conditions. Where is the prohibitory clause?
mm.
It should be read.
No, whether a separate prohibitory clause is required in the agreement.
Definitely, if you want to hold that argument,
Mm.
even in your termination letter, then you should have spelled out that see, you are bringing your articles, we are not agreeable to that, so you are thrown out. That is not the ground in the termination letter. Termination letter again is in the line of that those illegalities done regarding VAT and sale tax, my lord. Where they try to extract, if I read out the cross-examination of the builder, my lord, it will be surprising, my lord.
Mm.
It will be surprising. He glaringly admitted that there was no demand raised by anybody. He does not have any information on how much tax has to be raised, how much has not to be raised. Even then he will raise. Such recklessness, my lord. And this all because of, I respectfully submit, my lord, all because of the purpose when someone, this is a normal course point, we all know, a builder enters into an agreement with a gullible consumer, my lord. He extracts the money. Later on, he sees that the value of the flat rises. He tries to find out some excuse to terminate the contract and sell it to some other person with higher rate, my lord. That exactly has happened in this case.
Mm.
Lordship, he terminated the agreement. Had it not for the mercy of the civil court, this flat would have gone. The injunction order was passed by the civil court. Even then, in violation of the injunction order, my lord, many people were, some antisocial elements were inserted in inside the flat.
They still
My client had to go and file lodge an FIR, my lord.
Mm.
Then, my lord, somehow the possession was vacated, my lord. I mean, my lord, that vacancy was ensured.
Mm.
This is the state of affairs, my lord. And now coming at the, my lord, where they have pleaded that this is not a genuine document.
Mm.
Neither in cross-examination they could show that this exhibit 12 is a fraudulent document.
No, no. Whether on the basis of such kind of pleading, this kind of finding can be returned that there is mutual understanding between the parties.
Definitely, my lord, definitely. Because if I again read out paragraph 9, my lord, The
no,
the plain are not wholly correct. Once I say wholly correct, what does it mean, my lord?
no, it means that he
is
admitted
partially
it.
That means
Admitted
the
it.
arrangement is admitted.
Mhm.
Arrangement is admitted.
Mm.
Now, what else is denied, let us see, my lord. It is specifically denied. Now the denial comes. The statement there. On the state modification letter, the plaintiff had proposed and defendant number one and accepted for modification work stated there in the defendant number one shall be entitled to the payment of labor expenses for doing the modification work, and the material for carrying out of modification work will be supplied by the plaintiff at his own cost. It is stated as clause 25. Now, actually it is inverted comma is as 25 dated to so and so. It is specifically provided that extra payment so and so incurred will be so and so. Therefore, the plaintiff being the purchaser is liable for payment of any additional work done by the answering defendant as per his request. Let them show that additional work then. What inference the court will draw?
Mm.
If they could have shown that this X quantity of work was actually done by us, not as per your modification letter. You pay for that. This is the dispute. You have not paid for that. What is that? Because that work was never done. Not done at all, not even touched, my lord.
Mm.
So what else can be inferred by the learned court, my lord?
Mm. Okay. Okay, please sit down now. Take a.
My lord, regarding readiness and willingness, that's the
Okay, let him complete.
Lordship.
Let him complete.
No, my lord, everything will become clear from two more exhibits. It is not a case where it has always been a dispute whether that modification of 2013 was accepted or not. The lordship will now have exhibit 17.
Mm.
I did not flag mark it, my lord. It is there after that.
Yes.
And to precisely answer my friend, my lord, how this was never the case, my lord will see second paragraph.
Mm.
Very cleverly, my lord, he says, you have already agreed. If I may read that, my lord, you would recollect, the plaintiff says,
Mm.
you would recollect that you have agreed, second paragraph, my lord,
Mm.
you would recollect that you have agreed to adjust the expenses that will be incurred by the undersigned in doing the modification at the time of final payment.
Mm.
Surprisingly, although agreed earlier, presently you are not allowing the undersigned to do necessary modifications according to the wish of the undersigned, as a result of which the undersigned has incurred huge loss. In view of the above, question of making final payment does not arise. Moreover, due to past conduct of your organization, the undersigned is apprehensive that if final payments are made, you would not be adjusting the same against the modification works intended to be done by the undersigned, my lord. Do we need more clarity on this, my lord? He unequivocally says that remember you agreed in 2013 that I can do modifications on my own. So I will let me do the modification, then adjustment of balance amount would come. Till then, I will not make any payment because I do not trust you. And therefore, he says, in view of the above, question of making final payment does not arise. Where is his willingness, my lord? Now, to this, there is an answer. There is a response by the following exhibit, my lord.
Mm.
Exhibit 18. These are their exhibits, my lord.
Mm.
With reference to the aforementioned letter, that is the letter of 24/4/2014, which I just read.
Mm.
With reference to the aforementioned letter, I deny all statement and allegations made in your letter, as the same are neither correct nor based on facts. Please go through the agreement. There is a clause in respect of modification work. That extra payment must be incurred by the purchaser second party against the extra additional modification work subject to prior consent of the first party and will be executed by the first party only. And this, regarding the same, the purchaser cannot have any objection. And I repeatedly request you to make payment of the modification work along with the schedule of payment and enable me to complete the project as early as possible, my lord. Do we need more clarity than this? Despite of these two exhibits, my lord, these two exhibits were totally ignored, and the trial court, with utmost respect, assumes that there is a mutual understanding. Now the plaintiff tried to presuppose that you remember you have already agreed. Defendant says, no, I've not agreed. Because you would recall clause 25, only I can do modifications. And please pay me the modification, only then I can complete it. And from clause page 17, my ground of readiness and willingness is further substantiated because he says that I will not make any payment because I do not trust your organization. You may not make the adjustments later on.
No. Till the works are completed, why he should make payment of the?
No, works, my lord, I am supposed to complete.
Hmm.
I am supposed to complete. He says, I will complete the works. Till the time I complete the works, I will not make payment.
Hmm.
And he says, you're not allowing me. Then I say, my lord, that no, I'm not allowing. Then from where does the court infer, my lord, that there is a mutual understanding that he does the work and I make the adjustment? And now coming to the denial part, my lord. Denial part, my lord, he says not wholly correct. Then he specifically denies, it is specifically denied that you proposed and I accepted this term in contravention of clause 25. That is the precise language. And even thereafter, my lord, there are other paragraphs where where we've categorically stated that there is no, for example, if your lordship has page 48,
Hmm. Yes.
towards the middle of that paragraph number 14, my lord, the sentence begins with, it is further stated in the memo of
Paragraph number?
The first paragraph, my lord, that's part of para 14 only. The sentence begins with, it is further stated that in terms of clause 25. It is further stated that in terms of clause 25 of the agreement, the additional work will be executed by the first party only, and therefore the question of not allowing the plaintiff to do any modification by himself does not arise. So that has been the consistent stand of the developer builder. That can be gathered from the letters that were exchanged prior to the institution of the suit, from the pleadings in the written statement, that he always maintained that under clause 17 and 25, only I can make the constructions, and therefore, if you want modifications also, those modifications also I'll only do, you will have to pay me extra. And this is totally in contradistinction with the stand in Exhibit 12, where he says, I will do it and I will make the adjustments. And the letter at Exhibit 17 also, he clearly says that I will not make payment till I complete it, and therefore allow me to complete it. So,
but as submitted by Mr. Rahul, there is no prohibitory clause.
There is a prohibitory clause, my lord. I'll show, because your lordship, we are all aware, my lord, the clauses of the agreement have to be given their natural meaning, my lord. Now, if your lordship sees, so every word has to be assigned a meaning, my lord. Now, clause 17 says that the purchase, I'm sorry, my lord, I'm reading this clause over and over again just to gather the true intention of the parties, my lord. Page 42 is where your lordship finds the clause. The purchaser second party shall not be entitled to make any act, deed or thing in respect of the residential unit. It being clearly understood. So it is clearly understood that all acts, deeds or thing in respect of the residential unit shall be done only. The word is only, my lord. Shall be done only by the first party builder until it is handed over to the purchaser. So first of all, if we break down this clause, first of all, it says you will not do any act, deed or thing in respect of the residential unit, number one. Number two, you have clearly understood that all acts will be done by the building. And thirdly, it says, it qualifies it with another clarificatory word, only by the builder. And so is the language of clause 25. Even if the modifier works subject to the clause 25 also, it requires prior consent of the first party, not a unilateral arrangement that you shoot a letter in the form of document 13 and I accept it with unequivocally. It says prior consent of the first party and will be executed. Even when there is a consent, it will be executed by the first party. Again, the word is only. So only I can do it. Now, if you say 17 and 25 has been superseded and there has been a mutual understanding of sorts, they must prove that understanding. Manoj. And the larger question is, is it not acting at variance with the contract? Manoj? And another question is, when you say I will not pay you money until I complete the works because I don't trust you.
No, Mr. Deka, you say this observation was made by the trial court only in arriving at the finding that there is readiness and willingness
Exactly.
on the part of the plaintiff. Whether in arriving at such a decision, no, such a finding, strict interpretation of the clauses.
Yes,
of the
Manoj. Because Manoj,
of the agreement are required.
I would say yes, Manoj. Why I say is this because of this, Manoj. Willingness inheres in the mind, Manoj. And readiness is the capacity, Manoj. Willingness and readiness are both relatable to the terms of the contract. That am I willing to perform the contract in strictly in terms of the condition clauses and conditions, Manoj. Terms and conditions of the contract says I hand over everything to the builder. So therefore, I have to be willing to adhere to that I have left it upon the builder. So therefore, and secondly, my lord, payment. Payment is also unconditional. It doesn't say you take over, you complete, then you pay. It says I complete and then you pay periodically.
Mr. Deka, you see, he has already made payment of a sum of rupees 25 lakhs.
That I agree. He's paid the money. But now with the robust interpretation,
No,
that has
you
been-
see, having paid such a heavy amount,
My lord.
whether it can be said that he is not ready and willing.
My lord, because that is what I was coming to, my lord. In fact, there are recent judgments also. I have brought one or two, my lord, which have now said that, my lord, when it comes to specific performance, it's an equitable relief. So ultimately, you must show not that you have substantially performed your part of your obligation, but you have always been ready and willing throughout, and your conduct has been free from late.
No, it appears from the record that he is ready and
Well, ready and willingness throughout is what they have said.
yes,
Throughout. Now, the moment he
has only supplied the articles to be installed in his bathroom and door, etc., etc. Those fittings.
But that also, my lord, I have denied. I have said that that question doesn't arise because I will do the construction. And if you want modification,
No.
you tell me.
Are you denying that he carried the materials to the site?
Going by
and there later on you have not allowed him to take the same back?
I have said, my lord, how I cannot add words to what the letters say. The language of the letters are that you please refer to clause 25. The question of allowing you to come over does not even arise. That is the words used. So how your lordship interprets it is of course, my lord, but I have not accepted, admitted either that there was an understanding or that he came with the materials, etc. I have only
No,
said,
forget about that finding of the learned trial court.
Yes.
But going by this letter, Exhibit 12, especially the note referred by you,
Yes.
can it be said that he is not ready and he is not willing to perform his part of the
By
contract?
this note, what I'm trying to say, by this note, it is apparent that he is not willing to perform or comply with clause 17 and 25. And over and above that, my lord, I have been, my lord, just for a moment, if your lordship sees it from this angles, my lord. I say that I would have done it, my lord. Of course, there were some differences about the amount of taxation money he has to pay, etc., etc. I say that I was going ahead with the work. He comes forward with an absurd proposition that he will do the remaining of the works. Then he says that I will not pay you money. I write him a letter that please give me, if you want additional modification, give me money so that I can complete it. He doesn't pay me money. He rushes to the court for specific performance. Besides ordering specific performance, on the other hand, a compensation is imposed upon me that I sort of 14,000 to be precise per month I should now pay him. Whereas if he would have let things progress in the manner that the agreement provided for, then perhaps this eventuality would not have arisen. Because apparently he wanted to deviate from clause 17 and 24. So, my lord, other things aside, my lord, I would say, my lord, on the ground of perversity, Exhibit 12 was never even interpreted. Now, of course, all of us are trying to give it meaning, my lord, but trial court simply took it as an mutual understanding, and 17 and 18 were not even considered, my lord. The trial court assumed that there has an understanding, and I have already sort of conceded or acceded to that demand, and therefore, when I terminated, it was a breach of the contract, and hence I'm liable for specific performance.
Where is the termination order? Termination letter?
My lord, I think it's exhibit 19, the last exhibit.
Exhibit 9.
It says, as you fail to comply with the terms and conditions of the deed of agreement, deed number so and so, and in spite of our repeated request reminders, you did not pay any heed to pay the dues as demanded by us, as such as per clause 6 of the aforesaid deed of agreement, thereby cancel the deed number so and so. From today, booking of the said residential unit as well as the agreement will be treated as null and void, and you are hereby informed that the advance amount paid to us will be refunded after deducting cancellation charges and taxes as mentioned in clause 6 of the above mentioned deed of agreement. So we said we will refund.
That's all right. Another contention is of the plaintiff is that how you have assessed the VAT and the sale tax.
That my lord, the trial court also has come to a finding that those figures were not substantial. Of course, there are clauses in the
Then
agreement.
why should he agree to your demand?
Well, a demand in respect not just of tax dues, my lord, because he says modification and that also I've shown exhibit 17. Where he says you pay me if you want additional expenditure. So additional demands will not just include taxation demands, my lord, demands for additional work. And first it says, since it's a grammatical conjunction and, my lord, before that and it says you fail to comply with the terms and conditions of the agreement. Terms and conditions within its meaning would include 17 and 25 because you halted the progress and you said I will complete. That is what the tenor of exhibit.
Okay. You have any other point?
My lord, lastly, my lord, I think 12A. That should be all. I'll just check up the records and address one more point before I address it. Just something to do with the date. Stay getting pieces. Stay getting pieces. Stay getting pieces. My friend can continue.
Okay.
I'll come back.
Before I focus on my argument,
this appeal being a continuation of the suit, my lord. I come to the entire facts, my lord. What prompted us to file the suit, my lord?
No, that is not necessary. His only point is this readiness and
Only readiness will finish.
you come to that point.
My lord, appeal, my lord, we all know is a continuation.
No, that's all right. There is no dispute about it.
Page 30, then, page 30 of the memo of appeal
Mm,
is a clear cut averment in my claim, my lord.
mm. No, that you have already shown me.
Yes, sir, that the plaintiff says that he is a readiness.
Mm,
Page 30, my lord,
mm.
of the memo. Page 30 is, my lord, the relevant portion of the plaint, my lord.
Mm.
Page 30,
Paragraph number 70.
paragraph 17, my lord.
Mm.
The plaintiff states that he is ready and willing to perform his part of the promise contained in the agreement dated 24/4/2012 and pay the balance amount of the consideration money to the defendant number one towards purchase of the Schedule 2 flat, so far as the cost component of the flat is concerned. Leaving aside the tax in as much as whatever is assessed by the authority, the plaintiff is liable for. On the other hand, the defendants are liable to complete the construction of the Schedule 2 flat, hand over possession of the same to the plaintiff, and transfer the same to the in the name of the plaintiff by executing a registered same deed. Now, Lordship will come to their reply against this readiness and willingness in their receipt. Page 52, para 19. Page 51, my lord, should we have 51?
Mm. Yes.
This is in the written statement. That the answering defendants have denied statements made in paragraph 17 of the plaint as the same are not true. It is specifically denied that on the other hand, so entire paragraph is quoted, my lord.
Mm.
Paragraph is quoted. Then again it says, it is stated that the plaintiff who himself in violation of agreement failed to pay amount due in terms of agreement dated 24/4/12 has no right or authority to claim specific performance on part of the defendant on the basis of the said agreement. It is stated that admittedly plaintiff has paid rupees 25 lakhs 1,290 against agreed amount of rupees so and so. So there is a balance of rupees so and so is due. Apart from that amount, till cancellation of the agreement, plaintiff was liable to pay. This is very important. Lordship will kindly mark this. Apart from this, what is liable to pay is 77,283 rupees so and so penalty against non-payment of tax. Another amount of rupees towards the modification of the flat as per his specification on the date of cancellation of the agreement so and so is due from the plaintiff. Readiness and willingness is not denied, my lord.
No,
Whereas there is
maybe, but it has to be inferred from the conduct of the party.
Lordship.
It has to be inferred from the conduct of the parties also.
Yes, my lord, but my pleadings are clear that I am ready and willing to pay.
Mm.
Because readiness and willingness, my lord, as per the authorities of the apex court,
Mm.
has to be first inferred from the reading of the plaint.
Mm.
That whether I am ready and willing to pay or not.
Mm.
Secondly, my lord, if your lordship goes through the entire evidences on record, my unwillingness, even if it is presumed regarding the modification issue, my lord, can be presumed only when the modification work is completed by the builder.
Mm.
Here is a situation, nothing has been touched, no work has been touched, my lord. So where is the liability of the plaintiff to pay now?
Mm.
They are arguing on a point, my lord, it's a, my lord, endless argument, very academic argument rather, I would say. That whether I am entitled to, as part of process of the agreement, to furnish the material and ask them to bear the labor expenditure. All these arguments have been made, but at least show from the records that you have done the modification works. And then you have raised a bill upon me. Where is the modification work and where is the bill of modification work? That having not been done, my lord, the question of payment for modification does not arise. It does not become my contractual liability now. Yes, I might have suggested that let me do. Is it so wrong that you will go and cancel the agreement? And did I in fact execute the work? I did not. A professor, my lord, how can he go and fight against these powerful people, my lord? Huh? And my lord, this 25 lakhs is still lying with them. Bank loan is there. I have been paying EMI, my lord. In fact, the loan has to be discharged out of my salary, my lord. And if your lordship again goes to the termination letter, my lord, does your termination letter say anywhere that this X amount for modification has not been paid by me? Does any environment, any evidence anywhere have you demanded that money from me? You cannot because you have not done the modification work. What they demand, my lord, this is very interesting. There is my learned friend is very tactfully trying to at one point he has considered that was the wrong thing they have done. Now he's trying to shift the argument to something else. If I understand my lord, these pleadings of my lord here, they have categorically stated plaintiff is liable to pay 77,283 as tax, rupees 9,000 as penalty. My lord, penalty by whom? Where has the health department come and raise penalty against me? This is when this type of action should be strongly deprecated, my lord, in strongest of terms. This is an offense. A statutory, my lord, revenue, a revenue which is generated by the state out of the statute, my lord, that is tried to be imposed upon a purchaser, saying that you pay penalty to whom? Has the health department raised any penalty? I will come to the cross-examination part. I will take your lordship. Where has any penalty been raised? Lordship, well, see, again, then in the termination letter, in spite of our repeated requests, reminders, you did not pay any heed to pay dues as demanded by us.
That is exhibit?
Exhibit matter 19. Let us go to the content of the document.
Exhibit 5, C1. Yes.
Well, as you fail to comply with the terms and conditions of deed of agreement being deed so and so, April. My lord, a termination letter should specify which condition I have failed, which condition I have breached. At least so cause notice we have all read, it should be speaking enough, my lord.
No, Mr. Rahul, you say.
And in spite our repeated requests remind us you did not pay any heed to pay the dues demanded by us. What dues have you demanded? The tax.
This letter is not the subject matter of challenge in this appeal, no?
Lordship.
This letter, this termination letter is not the subject matter of challenge in this appeal.
My lord, that is the cause of action because of which I had to go to seek protection of the court, my lord.
No, that's all right. Now
My learned friend has very candidly submitted that these things would not have happened had we not pressured us for modification. But ultimately, they did not say that come forward. What was the duty of the builder? My lord, because of this type of actions of the builder, now the RERA has to be promulgated.
No, that's all right. We are on the point of readiness and willingness. You come to that point.
Readiness and willingness, my lord. What more can be there when even my lord off the record I am informed about this formality is unfortunate. What has happened? My client is also a very simple man. Recently, he has come to realize that bank has paid entire 29 lakhs to the builder. If your lordship desires, I can bring an additional affidavit on that record.
Okay.
It is unfortunate, my lord. My client was not diligent about after the judgment came, he came and told me that another thing, very fantastic thing has happened. The bank has released for entire payment to the builder. I said, very good.
So
25
Dekar,
lakhs,
now where is your case now?
Someone.
My lord?
If the entire amount
No,
has
I
been
don't
paid,
think that is correct, Mano, because
Is correct.
I'll have to check, Mano. I have serious doubts because
It's off the record, but I'm just informing you of the record, my lord.
no, because without sale lead, the bank cannot disburse. As per banking policy, either occupancy, sale lead, these are requirements. I don't understand how the bank would have done it. Then it's a illegality by the bank, Mano.
My lord, yeah, as per this year, 25 out of 29 lakhs, only 3 lakhs is remaining. And payment, I do not have to make the payment. Even, let us forget about that part, which I have said. Let us, 25 lakhs have already been released to them. It is not a case of not being ready to pay and unwillingness to pay. My cause of action, my lord, please understand my submission. My cause of action is when I felt that you are raising taxes.
no. We are not telling you that you have no cause of action.
Yes, lordship. Why I came seeking specific performance of contract? When I saw that initially some false demands, in fact, I will use the word term false. I will read the evidence, I will take your lordship, I will travel your lordship with that. When I saw that false demands have been raised against me in the name of tax and electricity due, I asked for clarifications, which they could not give. And that is the only demand that they have made upon me.
No, but if the amount has been paid,
I'll take
then
instructions.
I can place an additional affidavit, my lord. If your lordship permits me, I can place an advice, I can bring the banks up to the bank statement, my lord.
okay. Let it be on next Monday, on next Tuesday then.
Lordship.
Part Mr. Dekar, learned counsel for the appellant, Mr. Rahul.
Tuesday, my lord, I'll not be in town, my lord. Only for that point, my lord, whether the payment has been made or not.
Yes.
Then your lordship will have it on 7th, if not possible.
Pardon?
7th of May.
Yes.
7th.
Part in part, leaves the matter on 7th. During the course of argument, Mr. Rahul, learned counsel for the respondent, has apprised this court that the bank has already released 29 lakhs in favor of the appellant herein, and he will bring the same fact on record by filing an affidavit. And he pressed for listing the matter on 7th of May. Pair allowed presses to list the matter on 7th of May as part as top of the list item.
Item 18.
Obliged.
May it please your lordship.
Hmm.
My lord, case before your lordship, actually it is a concurrent judgment, my lord.
Hmm.
My lord, what happened? I am victim of a particular circumstances. My lord. Somebody, my lord, sell the property to me, my lord, on the basis of a execution of power of attorney by the landlord, my lord.
Hmm.
On that basis, my lord, I have purchased the land in 1997.
Hmm.
So ultimately, my lord, after 10 years, 2007, that original Patadar came with the plea that no, I have not executed any power of attorney. After 10 years, my lord. And ultimately, he said that no, I sold out the land to respondent number 1. And that is the case, my lord. Now, question is this, my lord,
here, your lordship would be pleased to see, they claim that the respondent number 1 claimed that he purchased the land from the landlord. But our claim is the land was purchased by us from a power of attorney holder 10 years back, and thereafter the suit is filed. Now, my lord, this is the case, and now your lordship would be pleased to see the substantial question of law framed in this case, my lord. It is order dated, my lord, 21/11/2022.
Mm.
My lord, substantial question of law number 1, I skip mine.
Mm.
I am not insisting on that. 1. But 2, my lord, I am to place before your lordship. Whether the learned lower appellate court committed illegality by depending upon the photocopy of document as exhibit 9 and exhibit 9(2).
Mm.
What is exhibit 9 and exhibit 9(2), my lord? It is the expert opinion, fingerprint expert opinion. And that fingerprint expert opinion, photocopy, my lord. Photocopy has been accepted by the court below.
No, that's all right. Whether that expert was examined,
My lord.
whether that expert was examined,
No, my lord.
not examined.
Not examined. Expert, my lord, subject to correction, my lord, whether examined or not. Exhibit 9, my lord. Exhibit 9 and exhibit 9(1).
Okay. 9(1) and
9(1) and 9(2) is the signature, my lord. PW block and I. Exhibit 9. 9(1) and 9(2).
No, these two documents were not not admitted being photocopy.
My lord.
As per the record of
My lord,
the
now, my lord, then subsidiary question will arise. If that expert opinion, exhibit 9 and 9(2)
Mm.
is not accepted, my lord,
Mm.
then this my basis is the power of attorney. And the power of attorney, my lord, that is the thumb impression was given, that is not exhibited, that is not admitted, then how that power of attorney is not a valid power of attorney held by the court below, my lord. My basis is the power of attorney.
Mm.
That power of attorney is to be disproved, that this thumb impression is not proper.
No, that was not at all admitted.
No, that is there, not at all admitted.
Mm.
But my humble submission before your lordship, it was executed. That is my case. Because, my lord, I am in that case, my lord, I am the
No, you
I
have
am
failed
the
to
third
produce.
party.
Mr. Sheikh, you see,
My lord,
you have failed to produce the original power of attorney.
my lord,
Rather, you produce the photocopy,
my lord.
and the court held that it is not applicable, not admitted. Court has not admitted it.
Well, question is this, my lord. In that case, I am the third party.
Mm.
Power of attorney exhibited by Mr. Pator,
Mm.
original landlord,
Mm.
in favor of another person, my lord.
Mm.
And that another person sold out the land to me.
Mm.
So, my lord, here now question arises, my lord. Power of attorney holder,
Mm.
he did not turn up.
Mm.
No, my lord, I purchased the land from him. He is not turned up. And power of attorney is in his custody, my lord. I could not produce the.
No, all right. You could have filed an application before the trial court
My lord.
to issue direction to him to produce the original power of attorney before the court.
My lord,
Did
that
you
is
file
there.
that application?
That is there, my lord. That may be a lapse. But your lordship will consider the faith of the appellant. That I
No,
have properly
Mr.
purchased the land.
No, Mr. Sheikh, you see, here strictly we have to go by the substantial question of law framed in this matter.
My lord.
If the exhibit 9.1 and 9.2 are not admitted,
My lord.
then where is from where the substantial question of law arises? Number 2.
My lord, that will go.
That
In
will
that
go.
case, that will go.
Mm.
Next question, your lordship will come.
Mm.
Next question, my lord, 3.
Mm.
Substantial question of law arises as to whether the learned lawyer appellate court committed illegality by ignoring the contradiction in respect of possession of the plaintiff by the defendant on 35/2006.
Contradictions.
Contradiction. Contradiction, my lord, it is a thing, my lord. He purchased the land, that this subsequent purchase from the landlord, my lord, by the respondent number 1.
You say
It was on 1/6/2006. 1/6/2006. But
no,
he said,
Mr. Sheikh, you say to ascertain whether there is serious contradiction or no contradiction at all,
my lord,
this court has to appreciate the evidence.
my lord.
But in second appeal, this court is not entitled to appreciate the evidence.
No, my lord, if, my lord, here my submission before your lordship,
Mm.
that what is substantial question of law.
Mm.
My lord, in CPC,
Mm.
always we used to use this word substantial question of law.
Mm.
But
So,
in
okay.
the whole CPC, my lord,
Mm.
that definition of substantial question of law is not there.
Not there, but it
What
is
is the
settled
what is
by.
substantial question of law?
Okay, it is settled by Supreme Court in several of its decisions.
Even our High Court also, my lord. Yes.
Petition to the Assembly. Mohondo, itu দিয়কচোন। ৰাতিপুৱা আইটো আছে আইটো নাম্বাৰটো মনত আছে ন অৰ্ডাৰটো আপলোড আছে ন এইটো ডাউনলোড কৰি দিম প্ৰিণ্ট আউট এটা ওলাই দিম
Thanks.
So, Mr. Sheikh,
My lord,
there's a decision of Supreme Court
my lord.
where it has dealt with what is substantial question of law. The decision is Santosh Hazare versus Purushottam Tiwari,
My lord.
reported in 2001, 3 SCC, page number 179.
My lord,
There,
may I write it down, my lord?
yes,
My lord. My lord, this reference, my lord,
yes,
please.
take down.
Yes, my lord. He's taking down, my lord.
Okay. Santosh Hazare
Santosh Hazari,
versus Purushottam Tiwari,
Purushottam Tiwari,
within bracket dead,
they,
by LRS,
Hmm.
reported in 2001,
To-
3 SCC, page number 179.
year of judgment, my lord, 2001.
Yes.
3 SCC,
3 SCC,
my lord,
page 179.
my lord, 179.
And another decision is there. HP Piarizan, HP Piarizan versus Dasappa, reported in 2006, 2 SCC,
My lord,
496.
my lord.
You go through
My lord.
this decision
I'll go through, my lord,
and you appraise this court on next day.
my lord.
Which of these 6
My lord,
substantial
your
questions of
lordship,
law are involved here?
My lord, what I am on this point of substantial question of law in CPC, this is not defined.
Mm.
And second point is this, my lord, in our High Court also, there is decision.
Mm.
If your lordship
Mm.
found, then there is some clear perversity.
Mm.
Clear perversity in the finding of the courts below.
Mm.
In that case also, my lord, that may be
Yes, that's
considered
all right.
as a
There is no doubt
substantial-
about it.
Yes, my
On
lord.
the point of perversity,
Perversity.
substantial question of law can be framed.
Anyhow, my lord,
But that substantial question of
Your lordship, that
law is
for
not.
this reference, my lord, let me go through, my lord. Let me go through. Yes. Reference to লাগলে কালকে এটা তো পুরো লিখে নেবো।
And in order to frame that substantial question of law, you have to
Well, not,
satisfy this court that
but,
there is perversity.
Actually, what happened, my lord? What I have taken in the substantial question of law as a whole that has been typed out in substantial question of law. Anyhow, my lord, let me examine
No, therefore,
their decisions, my lord,
therefore,
my lord.
you should be careful in suggesting the substantial question of law.
That's right, my lord. So, my lord, yes, my lord, I will look into.
Okay.
My lord, some date may be given, my lord.
Heard Mr. MSA, learned counsel for the
Since
appellant.
they are occupying by land, so short, very short that may kindly be given.
And Mr. Mahmood, learned counsel for the respondent.
Partner,
Heard in part, list the matter on when? Suggest that if
next week, any day.
My lord,
next week may not be possible.
my lord, after 10 years of my purchase, the suit was filed. Now my learned friend is very hurry just to throw me away.
I have
So-
filed case in 2007, title suit.
That's all right, but
They are
after 10 years of my
false
purchase,
cases, and in every case they have.
now my learned friend is very hurry that I should be
Yes,
thrown out.
money because you are occupying my land.
Anyhow, my lord, a date may be given,
26 May. 26 May.
26 May. Oblige, your lordship.
Partner.
Partner.
Right.
That's